not promote or promotion any illegal activities. All content provided by this channel is meant only for educational purpose only.
What's going on, people? We a little late. Don't worry about it. We a little late, but nothing we can't fix.
Yeah. Yo, the dope. Yeah. Yeah. The day hit different, phone rang like a church bell toll. Told the boy at the tavern, Saturday night shell crack. Stories he told. 4 deep in the whip, mission sealed in black ink. He wrote a check his ass couldn't cash. Now we coming to collect that link. Town tavern, lights low, shadow dancing on floor. We slid in quiet wolves in sheep clothes, eyes locked on the sword, sat across like chess masters, pawns ready to flip the board. No retreat, no surrender, 4 horsemen, death have been called. Turtle in the tavern, slow motion, think he's safe in his cup, but the reaper sent fall. Now the bill coming due. What's up? What? He wrote that check, now his ass in the red, feel the heat rise. But the ratchet skank shield popped up. Saved the turtle that night. Turtle in the tavern, slow motion, think he's safe in his cup, but the reaper sent foe. Now the bill coming due, feel the heat rise inside the spot. Tension thick like fog in the graveyard mist. One hitter goes to the bar, poking the bear, trying to get a reason to twist. Give me your look, give me your word, make this personal, fool. Turtle boy sipping slow, shell tucked tight, acting cool. Boss on the line, voice cold, he with a ratchet, hope position. Didn't plan for the extra variable. Skank in the equation, phone buzz twice, heartbeat sync with the bass in the back. Hitters itching, fingers twitching, ready to paint the whole scene black. Metaphors in motion, turtle versus the hawks in flight. Shell made of pixels, blogger life for real, still in sight. Ratchet turned savior, hood armor, lipstick like war paint. One wrong move and the whole tavern turned to a horror scene. Faint, boss said I'll call you back. Line went dead like a ghost, then it rang abort mission. Stand down, let the turtle boast. The ratchet skank saved them, unintentional guardian angel glow. Turned 4 killers to civilians with a presence alone. Turtle boy exhaled, never knew how close death did creep. Broke them blogs like swords, but that night his pen almost sleep. 4 guys dipped out, shadows melt back into the dark. Lesson learned, turtle got away that night. Left his mark. Next time, no ratchet shield, shall get cracked, no rehab. But tonight he walked free, and that's a different path. Yo.
What's up? What is up, everybody, man? How we doing? Shout out Honeybee. How's Robert doing? Anyone here from Robert? Shout out Robert, man. How we doing, man? Yeah, it's hot up in here. I might have to put the AC on. But what is going on, everybody? How we doing? We talked a little bit about the other day about Stephen Pina, and then I seen the W podcast. You know what I mean? Shout out to Maddie over there. Go over there and subscribe to the W Number Podcast. Don't forget to put the dash in, But I haven't heard from Robert, since before the Somerville event, since before the Eddie O'Brien event, man. Matter of fact, free Eddie O'Brien. Definitely let that be known. Free Eddie O'Brien, man. So we seen a few. No, he never made it to the event, and so I haven't really heard from him. I don't know if he might have commented since then, but yeah, man. So what is going on, man? If you haven't checked out the W Number Podcast, you gotta go over there and check it out, man. Maddie's doing a great job. We had him over here on the show yesterday. We talked to him a little bit. Free Eddie O'Brien. Absolutely, man. If you're over there on Twitter, man, come over on YouTube, and check it out. To the couple people that are over there, come over to YouTube, man. But what is going on, man? We're going to talk a little bit about Stephen Pina today. I researched him a little bit the other day. I researched him a little bit a couple of days ago, and I did a quick show on him talking about his talking about, how he's an exoneree now. He's been exonerated, but he did his first interview after being exonerated, for the crime that he always said he didn't do. Stephen Pina always maintained that he did not commit that crime, just like Eddie. Stephen Pina's story never changed. Shared this, so I watched the entire W Number podcast last night, and I think he's gonna have Rachel Rollins on, so that's gonna be very interesting. See how she connects to the Stephen Pina case. But after, like you heard him, he said after 32 years, 10 months, and 7 days incarcerated, he finally had a chance to speak openly. And he was very comfortable with Maddie. Maddie has a way, Maddie got him very comfortable. It wasn't an interview. It was more like a conversation that I seen over there. He definitely did say, his insistence on remembering the victim, Keith Robinson, and the pain of the victim's family. I respected that, and but the victim's family still believes that Stephen, committed this horrible crime when there's enough evidence to point elsewhere, and that's the problem. That's the problem with the Downing family. It's easier to believe a lie. It's easier to believe the lie than to believe the truth. But the Stephen Pina case was a messed up, shitty ass investigation, right? It had some shaky witness statements, they even look, it don't stop. And yes, Bud is sitting on this panel. We're gonna get into it. We're actually gonna watch the hearing itself. We're gonna watch the Stephen Pina hearing. I just had it up here somewhere. Yep, there it is. Okay. Yep, we're gonna watch the Stephen Pina. They may be trauma bonded to the lie. Yeah, but it's easier to believe the lie, they want to, and ignoring the evidence, but if you look at the withheld police reports, the ignored evidence, come on now. Evidence that pointed, just like Eddie, to a third-party culprit. Definitely a lazy mentality. But his experience in jail, awaiting trial, included some bad thoughts. The Lifeline program, witnessing another inmate take his own life, really gave Stephen, from what I understand, a new look at life, man. The first couple of trials he had, hung jury. The second resulting in a conviction after, more problematic jury instructions. And like always, right? Inoffensive, effective defense trial, of course. Years of appeals. Stephen put in years of appeals, all of them denied, despite inconsistencies, right? Despite misconduct, but I gotta say, man, when he was finally exonerated, man, it had to validate him, which he said from day one he didn't do it. And the emotional aftermath that this has to have. Even now, you lost 32 years of your life. you know, and Stephen also talked about on the W Number podcast about the compensation that will follow, you know, the money that will come. And people are like, oh, you're going to have like $1 million, 2 million, 5 million, 10 million. You know, it's like hitting the lottery. He said, no, it ain't. It's not like hitting the lottery. You know, we paid for that money. We put in the pain for that money. So they're paying you for your pain, paying you for your suffering. You know, $1 million is not a lot of money, even if it is a mil, you know, for 28 years of a man's life. You know, I'm sorry, 32 years of a man's life. They're not only 32 years, 10 months, 7 days of a man's life. So it was a great episode over there on the W Number. You know, he did a great job. And, you know, I appreciated how Stephen, you know, was insistent on remembering the victims. You know, he said, I have a lot of pain for the victim's family, even though they still think I committed this horrible crime. You know, now he filed this appeal in 2020, which I didn't like hearing that, knowing that we're in 2026, because I want to get my guy Eddie home. We don't have 6 years. You know what I mean? We don't have 6 years. But when Stephen talked about the emotional aftermath, the impact on his mother, the impact on his son, you know, the identity of himself, the pride he feels now walking free. You know what I mean? Dancing out of court, even though with a couple badass knees. you know, Maddie did a great job unpacking decades of trauma, decades of injustice. They talked about other people that were maintaining their innocence. You know, he shouted out Eddie a couple times. Shout out to Eddie O'Brien. Shout out to, I see Aunt Jerry in the chat. You know what I mean? We got to start sharing this, hitting the like button. But yeah, we're going to get into this, you know. But Pina did stress, though, although he was exonerated, that the victim's family believes he killed their loved ones. And he's, you know, he reflected on the victim's son growing up without a father. And, you know, that kind of gets to you a little bit. You know what I mean? He talked about refusing bitterness, that there was no time for that. You know, he credits the faith for keeping him grounded, you know, growing up a Jehovah Witness. You know, yeah, it was a very good, you know, episode. You know, matter of fact, before we get into the SJC, we'll get into this a little bit. Shout out to Maddie. This man had all of it counted. He had it counted down to the seconds.
Man, I'm my mother's only child. At 58, I'll be 59 September 1st. I'm my mother's baby. Still. Be like, Mom, come on. She'd be like, no, you my baby. My mother was my number one advocate, bro. And for her to see this.
I bet Mrs. O'Brien can relate to this. You know what I mean? We're going to watch the hearing, but I want to check a little bit about Maddie's podcast and go over there to the W Number podcast. Tell them, Can We Keep It Real sent you. You know what I mean? Subscribe over there. Help him out. Do whatever you can. You know what I mean? Maddie actually knows Eddie. He talked a lot about Eddie on the show I did I think I did it yesterday. No, the day before yesterday. I got to get this ugly turtles picture off my screen before this guy breaks it. There we go. Maybe some exoneration in the background. You know, all right, let's get back into seeing what he's talking. He said his mother was his biggest advocate.
My son was born a month after I turned myself in. Turned myself October 6th. He was born November 28th, right? My son's mother held on for as long as she could. But people look at my mother. They looked at my mother different. They looked at my son different. They looked at his mother different. Because
I wish Trisha was here to speak on this, because Mrs. O'Brien talked about this. Mrs. O'Brien talked about, you know, how she had to walk around with her head down. And then finally, it wasn't too long ago when she was on my show, and she said, you know what, Mikey? I don't have to walk around with my head down anymore, because people come up to me and was like, I feel your pain. I believe in your son. And Stephen Pina is talking about the same stuff right here. You know, go over there and check out this entire show. We're gonna touch on a couple little pieces of it, you know, and then we're gonna get into the hearing and watch the bullshit that the Commonwealth tries in that, man. Boy, they're like, man, you believe they really said that they don't believe? This prosecutor really got up there and said during the hearings, right, in the Stephen Pina case, that he don't believe in wrongly conviction. He don't believe that people are falsely convicted. What are y'all gonna say about that? On Jerry, what do you think? Do you believe in wrongly conviction? Do you believe in false, you know, imprisonment? Do you believe? Let me know, because the prosecutor in this case don't believe in it. You know, the prosecutor in this case said, I don't believe in it, and we're going to watch it. This poor guy's mother had to walk around with her head down. Not anymore.
because to them, your dad is a murderer. Your son is a murderer, no matter what I say. So when this came down, bro, I needed my mom, my son, and his mother to be standing next to me. Mm. His mother lives in Florida, so she couldn't be here. But I needed them standing next to me, them with me on that day, bro, because it's like, yo, we walked out of that courtroom like this.
Fact. With your head, you better motherfucking believe it, and excuse my language. You better believe it. Absolutely. Aunt Jerry said, I'm living it. Not anymore, Aunt Jerry. Now you can walk with your head high. Look at him. We walked with our head high. We had our head high. Yo, I got the goosebumps right now. I'm getting emotional over, like, I got the goosebumps. Until you know what it's like to live in these places that these men were in for so many years, I don't know if you'll get it. Until you know the bullshit that goes on in these prisons, behind these walls, the violence, I don't know if you'll understand. But Stephen Pina's mother was his strongest advocate. This man grew up with the stigma. His son had to grow up with the stigma. The son of a murderer. Respectfully, that's crazy, this poor kid. But they refused to be bitter. He refused to be bitter.
You understand what I'm saying?
Chest out, man.
Out of that courtroom like this.
Fact, bro.
You understand what I'm saying?
Chest out, man. Yo.
We told y'all from day one, I didn't do this.
Word.
We're glowing right now, bro.
Fact.
All of us, man.
Fact.
People are seeing me and they like, yo, man, you got a pep in your step. I'm like, man, like I told the Globe, right? Whenever I would go and speak to organizations, schools, and colleges, I would always introduce myself as Commonwealth versus Stephen Pina because I was free but still fighting.
Fact. Yeah.
That's right.
I am no longer Commonwealth versus Stephen Pina.
Fact.
Praise God, man. He said, I'm no longer Commonwealth versus Stephen Pina. You know what I mean? That shit just gives me the goosebumps. You know what I mean? Gives me the goosebumps.
Man, because, okay, cool, man, cool.
So check this out, right?
Because I could do this, bro. Like,
Word, bro. So this is the story I've been waiting for, man. So check it out. Going back before your crime, right? Who are you? Where are you from? And what are you doing?
I'm from.
Who are you? I like that one. You know, who are you? He said, wrongly convicted is so undervalued and overlooked. And society rarely reverses its initial judgment of a person, sadly. You know, but if you want to watch this entire interview right here, you know, go over to the W Number podcast, you know, tell Maddie Mikey sent you. You know what I mean? But yeah, Stephen talks about, you know, being raised in Boston, growing up a Jehovah's Witness.
I'm from the building, 1850, man, 50 side, you know. Back when I was younger, you know, I was just Stevie, man. You know, my mother used to yell out the window when it was time to come in, Stevie. And growing up where I grew up, everybody knew each other.
Yeah.
You know what I'm saying? All the neighbors knew each other. Of course, I got caught up at, you know, I grew up Jehovah's Witness, man, since I was 7. I think that organization, Jehovah's Witness, saved my mother's life.
And that was Brockton, you said?
No, Boston.
Boston, okay.
1850 Washington Street.
Oh, 1850 Washington Street. Okay.
Her becoming a Jehovah's Witness saved her life. It gave me my mom back. You know what I'm saying?
Yeah.
And my mother raised me in that.
Did she not, like when you say gave your mother back, what was she?
Well, you know, Moms was a partier, man. You know what I'm saying? She wasn't a drug addict or nothing like that, but she worked midnights, 11 to 7. And you know, when I seen her, you know, and there were things that I went through while she.
Salute to Maddie for asking, you know, the tough questions. Let's come up here and check out the moment that you know, he learned that he was wanted for this horrible crime.
Right.
And then I got another call that I was wanted for murder. And I'm like, what? Like, I ain't killed nobody, you know. So I called my mom that I was attempted murder and called me from one of my 2-3 weeks there. I got a call from one of my boys saying, well, my cousin called me first and she said, hey, I heard you was wanted for attempted murder. That's why you left. And I'm like, nah, what you talking about?
Right.
And then
Stephen ended up moving out to Atlanta, you know, to prepare for fatherhood. That's where his baby's mom was. And people were calling him saying, yo, bro, Popo looking for you. First for attempted and then for the red rum charge. You know?
Another call that I was wanted for murder. And I'm like, what? Like, I ain't killed nobody, you know. So I called my mom and I'm like, Mom, had the police been by the house? She was like, no. But one of my boys called me and was like, yo, man, the police was down that way, man. They was asking questions. They stopped my man Dion because Dion and I looked alike.
Yeah.
And they was like, yo, is this him? And he's like, nah. So and I'm like, what? And at that time, you know, I called my mother. And she's like, no, the police never been by here. And there were 2 officers that used to always mess with me, man.
Mm.
So I took a chance. I told my mom, I said, Mom, call D4, ask for officer such and such, and ask him like what's going on.
Right.
So that's what she did. The officer told her, yeah, Miss Pina, we know he's in Georgia, but yes, there is an active warrant for murder.
What's that feeling like?
That's what I was just going to say right there. Like, what does that feel like? Go over there to the W Number Podcast. Definitely check out, you know, support Matty. He did some crazy ass mass and casts. You know, he's really like going to the places that people don't want to go. Going to the shelters, going to the Ville. You know what I mean? Going down there to Roxbury, you know, mass and casts.
When I found that out, bro, like, first was like, what? I ain't killed. What the fuck are they talking about?
Right.
And they were like, something that happened on Mission Hill. And all I could think about at that time, down Mission Hill, the homicide that I remember was Jimmy Clark.
Mm.
And a woman named Tata is who they had for that.
Right.
You know what I'm saying? He shot her. She shot and killed him. He paralyzed her. And that's what I'm thinking all along. Like, how they gonna, you know what I mean?
Mm.
And I come back. No, I go see my dad and my uncle. I tell them what's up. They make some phone calls. My dad knew one of the homicide detectives. And he's like, all right, he's on his way back.
Mm.
I'm not going to play it all. I want you guys to go and watch this. We're just going to check out a couple moments. You know, I want to hear about the part where he talked about that the deputy sliding a Bible under his door, which he said really saved him.
That night he hung himself.
Jesus, man.
Right next to me.
Jeez.
So I'm in my window looking out and I'm seeing them working on this dude. And all I could.
Now, at this point, he's just talking about how he had these horrible black thoughts. You're doing a life bid for a crime you didn't commit. It's understandable. It's understandable. And then, you know, he's having these thoughts, and then he witnesses another inmate 86 himself.
I think was his girl must have came and told him something that, and I said, yo, I made it through thinking like that without doing that, which was a permanent solution to a temporary problem.
That's a fact.
They had a group called Lifeline at Nashville Street. And I remember asking for Lifeline and nobody ever came to see me. Lifeline was other mates who were part of that, who someone having those thoughts would ask for Lifeline.
Yeah.
I would go and I would sit down with this person. So I asked to be on Lifeline.
As a person going through what you were going through.
I asked to be on Lifeline because I didn't want I learned, yo, you're talking a permanent solution to a temporary problem.
So that
And I mean, I don't know how temporary his problem actually is. But let's get over to because I don't want to watch the entire thing.
SJC.
Oops. I want to get into this hearing a little bit. I'll tell you what, the shit that Stephen Pina had to go through. You know, how he described, you know, the decade-long time he did, the 28 plus years that was built on, you know, bullshit witnesses, you know, withheld evidence, right? Misconduct by the prosecutors. Sound familiar? Systematic bias. Sound familiar? Which one of these is Bud? Is it this one? Is it this one? It probably is. It probably is this one. The age looks right. Yep, permanent solution to a temporary problem. You know, we'll go back and check that out, but go over there to Maddie's page. You know, we had Maddie on a couple of on our last show that I actually done. We're gonna stop putting shows after we record them. We're gonna put them in the membership, you know, section for, you know, for a day or so, you know, before we let them be public, so the members can get a chance, you know, so the members can feel like that they have something, you know. You know, but this, you know, the evidence was BS in this case, you know. You know, so what I did is I got the SJC hearing transcript last night while I was working. Yes, I know I drive, but, you know, I did it safely, you know, and I went through it, you know, and, you know, reading the case about, you know, Stephen Pina and just seeing how it all went down, you know. But I think before we talk about justice, you know what I mean? I think we got to talk about what happens when the system forgets what justice even is. We're seeing prosecutors that forgot what being a prosecutor was. You know what I mean? A lot of these prosecutors, they don't know what being a prosecutor really is. We've been seeing it. We've been seeing what a prosecutor is. We've seen it in Karen Reed. You go back, you see it in the Eddie O'Brien trial. We're going to see it right here in 2026 at the SJC. You know, these people say, like, right in the beginning that they don't believe that people are wrongly convicted. Imagine that bullshit. So we're going to step inside a room that most people will never, ever see. The Massachusetts Supreme Judicial Court, right? Where every word is dissect. They pause for a reason, you know, and mistakes can cost people their life in this room, you know, and oh, that's what I'm talking about. Thank you. Thank you for the 1999 exonerate Eddie O'Brien. Tom Riley is the real criminal. Shout out to 2 Cents Work. Wants to talk some NASCAR. The only thing is now with NASCAR, it's like, not to get off subject, but a lot of these new NASCAR drivers are babies, 20 years old. I think Denny Hamlin is the only one that I really know that's still racing. Everyone else all retired. Dale Jr., you know, having brain issues. You know, Kevin Harvick stepped out of it. Big shout out to Erin Murphy, you know, holding it down. You know, watching my back. You know, good people over there. Erin is good people. You know, but like I said, we step inside a room that most people will never ever see, you know, and that's this room, you know, the SJC. And I think someone said the S is bullshit. I like that. Supreme. There's no Supreme there, huh? Thank you for the 1999. And I really appreciate that, man. Freebird came through the other day, dropped off 100 piece, you know, which, thank you. I really appreciate that. Because you know what? If Jess Machado can be making $10,000 a month, can I get 1,000 a month? I'm happy with $1,000 a month. I've been in that courthouse. I bet you have, Jerry. I'm not surprised in that. What did Eddie go there twice? You know, during the transfer hearing? Corrupt Criminal Award, the CCA. There we go. We call them the CCA. You know, but to argue that so the Commonwealth, I guess, gets up first, right? Yeah, she even said it, man. Like she's making $10,000 a month. $10,000 a month to go over there and get people listen to her, get cappuccino, and her and Turtle Boy's arguing, and Turtle Boy's like, "Oh, you think that's a lot of money?" It is. To sit behind a computer and talk about the stuff that like she's gossiping with her girlfriends. $10,000 a month is a lot of money for doing that. You know, she went on vacation twice. I think she's going to buy a new car. You know, good for her. You know, good for her. You know, absolutely. Always got to keep it real. Keep it authentic. Always keep it 100, right? You know, so, you know, these people, man, the Commonwealth in this case, right? Like, they didn't even admit wrong, the cowards that they are. Imagine, I can't even process 10,000 a month. I know it. She said not all months are 10,000, but on a regular, that's the average, about 10 grand a month. You know what I mean? I think she said someone gave her like 20 racks. I don't know if it was J7. J7 gave somebody some money. You know, but anyway, you know, when the Commonwealth gets up in this case, they don't even try to admit that they're friggin' wrong. You know, let's watch some of this shit.
Okay, Attorney McLean.
Good morning, may it please the court. Ian McLean on behalf of the Commonwealth, and I'd like to acknowledge Rosetta Lewis, the sister of the murdered victim, Keith Robinson, observing the argument today.
So you just wanted to acknowledge that the victim's sister was in the courtroom. And for the victim's family, just like the Downings, it's easier to believe the lie. It's easier to believe the lie. But how about the decades that Stephen Pina had to spend behind bars for a crime that he always said he didn't commit?
The motion judge here committed a series of legal errors when he allowed this motion for new trial, the third motion for new trial, over a trial that he did not preside over. Beginning with the first issue, the post-it note in the treatment records, he committed a series of errors on that issue. First, whether the defendants could have obtained the treatment records at all. Second, if they had obtained the treatment records, finding there was impeachment value in there was none.
What he's arguing over is, in this case, one of the witnesses one of the witnesses in this case was in a psychiatric hospital. I can't even afford a pizza. Oh my God, I want to send you a pizza. Can I send you a pizza? Is there a way to do it? You need $10. You need something for a pizza? I hear you though. You know, yeah, but this guy, man, like, you know, this is something that Stephen Pina, you know, spent a lot of time behind bars for a crime that he always said he didn't commit. And then this guy says that he don't believe in false convictions. That's crazy by itself.
Third, in the proffered experts at the defense.
Yeah, so like I was saying, I got off. I forgot my train of thought. The star witness in this case was in a damn psychiatric hospital, Taunton Hospital, and they didn't even tell the defense that he had a nut job testifying against him. Their star witness, Anus, was her name. Something, I think, Debbie Anus. That looks like Karen Reed right there. Deborah Anus was her name, from a friggin' psychiatric hospital.
Defendants utilized, they would never have been allowed to testify at trial based on their credentials and their background. And then fourth, in his analysis of prejudice as a result of not having these treatment records, and that he failed to grapple with the strength of the Commonwealth's case at all. So starting with the first error, obtaining the treatment records. This trial was in the 90s. So whether or not the defendant could have obtained the treatment records would not be analyzed under the Dwyer Protocol, which came into existence in 2006. It would have been under the Bishop Protocol that existed as of 1990.
Should it matter? So he's saying now you can get the treatment records, but it wouldn't have mattered then. Wait a minute. If the jury knew that this lady was in a psychiatric hospital, that wouldn't have affected her testimony. You know, like the jury wouldn't have looked at that like maybe a little bit differently.
93. What they offered here at the motion for new trial doesn't even come close to clearing the Bishop Protocol. All that they offered here was the mere fact that there were treatment records.
I was around during that period of time and utilized Bishop Fuller. And it seems to me that when you have information like that under the Bishop Protocol, it would go to the judge, correct?
That's the first step.
Was the fallacy of that the judge would have to step in the shoes of the defense attorney, but required.
So would the judge become fact
Will you
finder?
have?
Is that what he's saying? That the judge would become. I mean, on one side, you got the Commonwealth standing tall, flawless, arguing that the judge who finally saw the truth messed up. That's what he's saying. Not the judge that heard the case, the judge that finally saw the error. He's saying, oh, he messed up by giving Stephen. That's what I'm hearing.
An important witness. And
the most important witness.
No. Witnesses under psychiatric care. You don't think that a judge would say, this requires me to look at these records?
It might under Dwyer, but the initial step of the Bishop Protocol required defendant, and that showing was at a minimum a likelihood that the records contain relevant evidence to justify judicial review.
Correct.
Then a few years later.
It strikes me that a judge who has a witness who has psychiatric issues, and it always would then raise the issue of the ability of the witness to perceive, remember, and the witness's impairments, that would satisfy that standard.
Well, I completely disagree with you, Your Honor. I mean,
this guy, man, are you serious? The judge is the fact finder.
Seasonal affective disorder is a mental health condition, and that has nothing to do with a witness's ability to perceive, recall events, or be a witness at all. The Bishop Protocol, the way it existed at the time, said the likelihood that the records will. And then,
So if you think a Superior Court judge going back in the 90s has a Post-it note and says that this witness, who's the most important witness in the case, is under psychiatric care hospital, so I don't have to look at it?
that's exactly what the judge said in Bourgeois.
Wow. So it could be a seasonal, something. I shouldn't have to look at it.
In 2007. Mere existence of records does not meet the initial burden to judge.
That witness, he witnessed in the case.
I believe themselves, Your Honor, in Bourgeois.
Okay.
So the judge acknowledged the existence of the Bishop Fuller protocol. It's not even in his memorandum and order on the motion for new trial. So he didn't even grapple with it. He just said they get them. So that was an error of law. He didn't even apply the controlling law to the relevant question. So error of law. But even if you're going to say that was not an error of law, and you're going to say they would have gotten the treatment records for an in-camera review, then we turn to look at the content of the treatment records themselves. And this leads to his second error, saying that they contained impeachment material. They simply did not. To begin with, he made no factual findings at all to support a conclusion that they contained impeachment material. Zero factual findings. The mere existence of a mental health condition provides a line of meaningful cross-examination to impeach that witness.
So right away, what this idiot is saying, right? This guy walks in swinging his Johnson, right? He says that, the judge made 4 big mistakes. He's like, the defense shouldn't have gotten the psychiatric records. And even if they did, he said those records shouldn't have been used. The expert who testified, man.
What about the fact that she was hospitalized at the time she testified? That's not a line of impeachment?
The mere fact that you're hospitalized is not, Your Honor. The symptoms of what you're hospitalized for. You could have
psychiatric care, personality disorders. See, this is the problem with prosecutors. They forgot that they're there for justice no matter which way it takes them.
been hospitalized for a heart condition, and that doesn't provide a meaningful basis for it.
So then she's suicidal, I thought.
Yes, she was suicidal. She was in custody for an unrelated case, and she made suicidal ideations and was refusing to eat at the time.
So sticking with that fact, answer Justice Willa-Hojan's question.
I don't see how someone engaging in suicidal ideations means that they are, how does that provide a line to challenge their truthfulness, their ability to perceive events, or their memory? Those are the three things that we talk about when we're impeaching a witness.
Well, you started off by listing all of the issues that you have, at least with this particular, the psychiatric records. And you dismissed the two people that the defendant called for expert witnesses. Didn't those two doctors testify that at the time
Cellmark, your chosen lab expert in the game, tested the blood, telling the world the name. Eddie O'Brien said with conviction, but the truth came out like a hidden addiction. DNA tested, but what did it show? Excluded my man in that courtroom flow. Not a maybe, not a doubt, they sealed the fate. How you sell that story when the evidence won't wait? Stabbings and chaos, the narrative spins, but the DNA's whispering, where do we begin? You're trying to pin the blame Eddie's fate. How do you even tell when facts slip away? We dance round the lies like the night turns to day. Lights dim down, jury on pause in the courtroom theater. I'm just a part of the cause. You're trying to pin the blame, but you're missing the mark. Eddie's outside, lit up, nothing but dark. Can't blame the dog when it wasn't even home. This ain't a fair fight. Eddie's been alone. Oh, chaos in the streets, but the truth won't die. You can try to twist the knife, but look me in the eye. Exclusions in the lab, but you still wanna shout. Did it run through your veins? What's this all about? You're trying to pin the blame, but you're missing the mark. Eddie's outside, lit up, nothing but dark. Can't blame the dog when it wasn't even home. This ain't a fair fight. Eddie's been alone. You believe in the shadow, but the light's never wrong. Eddie O'Brien's excluded. That's where you belong. How you gonna sell that story? Leave him out in the cold, in the echoes of justice. The truth's always bold. In the courtroom lights, truth's gonna bend. Heffernan standing tall, trying to defend. Said it looked bad on paper, but it's all deeper. Politics lurking, call it a grim reaper. Eddie was just a kid, caught in the fray, but the power players had a game to play. From day one, they wanted him to fall. A kid in the spotlight, crushed by it all. Heffernan knew the truth. No, it ain't fair. Politics behind the scenes, no one would care. Guilty or innocent, the verdict was set. Justice wasn't blind, it was a political bet. Dr. Bonham was chosen, thought he would be right. A face of fairness in that long, dark night. But the DA smiled wide, played both sides slick. Heffernan thought neutral, but maybe that's the trick. Sealed with a stroke of a pen, my ruling was sound, but the world turned again. They needed him guilty to fit their plan, change the laws mid-game. Oh, what a scam! Heffernan knew the truth. No, it ain't fair. Politics behind the scenes, no one would care. Guilty or innocent, the verdict was set. Justice wasn't blind, it was a political bet. Juvenile court, he should have stayed there. 20 years, not a slap, but no one would care. System in panic cause he stood his ground, but the wheels of justice just turned him around. They wanted Eddie down, they wanted him lost. With the stakes so high, he paid the cost. Heffernan's truth reigned clear in the dark. Tried to bring light, but it missed the mark. Eddie, a kid caught in a game, lost in the shuffle, society's shame. So here's a lesson carved deep as stone. Justice should shouldn't wear a political tone. Heffernan stood firm, knew it wasn't just. In a world focused on power, who can you trust? Heffernan knew the truth. No, it ain't fair. Politics behind the scenes, no one would care. Guilty or innocent, the verdict was set. Justice wasn't blind, it was a political bet. The tales of the innocent, the truth yet told. Heffernan knew the truth, and it cuts like a knife in the courtroom of power.
Thank you very much.
What's the cost of
Shout
life?
out to 2 cents, member 3 months. All right, man, we back. Did I lose everybody? Did everybody fall off? What happened? Someone tell me. My shit just went down. My whole computer crashed. I bought a new computer, right? But when I went to the event in Somerville, I dropped it. Trying to get out of that hotel. I dropped it. So now, like, shit's all shaky. So now, I got to buy another damn laptop. I appreciate that, man. I appreciate that 2 cents. Shout out to you. Because there's a lot more cases that we could be talking about. Good. I'm glad everything looks good. All right. Yeah, shit just went dead. So I had to reboot everything. You're good on Jerry back in the house. All right. We'll let a few people get back up in here. So what do you think so far of this hearing? You know what I mean? They basically saying that, what were they saying? That, like what I gathered, that they were saying that, the lady was in a nut hospital, but that had nothing to do with anything. I'm like, are you serious? That had nothing to do with anything? I mean, the eyewitness was in a psychiatric hospital when she testified. But let's get back into this. Hold on, I gotta reshare it and everything. Yeah, it should be. But I don't know about when you drop it, when you break it and when you drop it. I think the warranty is only if it's internal, if the computer broke itself. So I got to check on that. Nice. We'll get back into this sucker.
ability to perceive events or their memory. Those are the three things we talk about when we're impeaching a witness.
Well, you started off by listing all of the issues that you have, at least with this particular, the psychiatric records, and you the two that the defendant called witnesses. Didn't those two doctors testify that at the time this witness was suffering from borderline personality disorder and antisocial personality disorder?
Well, first off, Your Honor, that's not accurate. What the witness was diagnosed with was personality disorder with borderline and antisocial features. That specifically means she does not meet the diagnostic criteria for borderline or antisocial. It means she has some of the features, some of the symptoms of the conditions.
Granted, it might not be line up directly, but both of those witnesses also then tethered those diagnoses to a witness's ability to perceive.
Well, all right, let's start with Dr. Franklin then, Your Honor. Dr. Franklin admitted that her opinions about antisocial personality disorder were speculation. Her words, speculation. That's at volume 1, page 121 to 122. And that those opinions have zero support in the academic studies. There's no value there. So that witness never diagnosed or treated a patient, never even interacted with a person with borderline personality disorder, never met Annis, never tested her memory, never looked at any brain images of her to show that her brain was malfunctioning in some way.
So the burden you have is that Judge Krupp had a hearing, and now you have to discount these expert witnesses as clearly erroneous, correct?
Yes, well,
his finding is
so yes, if he had made any factual findings, but the point is he didn't make any factual findings about how any of these medical situations would have pertained to her ability to be a witness. And the fact that you have a mental health condition is not relevant. It is the symptoms of that mental health condition, and it only becomes relevant if they affect your ability to be a witness, which means borderline personality disorder, the symptoms are mood instability and behavioral disruptions. That has nothing
I understand that you disagree, but if we marry this with Justice Gaziano's point, you don't have in the record that Judge Krupp discredited the witnesses that were produced by the defendant as part of the motion. These two doctors, Dr. Franklin or Dr. Is it Kleonsky?
That's my understanding.
Okay.
My bad. This is the moment I think where this shit just falls apart for the Commonwealth. Their whole argument and why that the SJC rejected the Commonwealth's position and upheld the new trial. But this guy basically said personality disorder. Hi, Jerry, Mike, and everyone. Sorry, I'm driving and listening. Oh, it's okay. It's okay. We're looking over, but the Commonwealth was so wrong in this. But it seems like they're trying to argue that what Judge Krupp made a bunch of legal errors by granting a new trial. What, the judge shouldn't have looked at the evidence? He says that. And even if he did look at it, it shouldn't count. Huh? And he said, even if it does count, it shouldn't even matter. Like, what the hell? Where do you find these guys? Where do you find these people?
Okay. You don't have in the record that he discredited these two folks.
Not that he discredited them, but he didn't make any affirmative factual findings that would justify a legal conclusion that there was any impeachment value.
So leave us again, assuming that you disagree with this, it's not a reasonable inference that he credited their testimony, even though there's the concern about whether or not it might meet a Dober-Lanigan burden at trial. For purposes of a motion for a new trial, he's not able to credit the fact that this doctor said, hey, this might affect her ability to perceive and memory.
If he had expressly written, I credit this witness, I would agree with you. He did not do that here, and he made zero relevant factual findings. If you want to infer that he credited the witness, that means he credited Franklin, saying, my opinions are speculation and there's zero support in the academic studies for them.
Sure.
I don't see how that could support the legal.
Because he's also the fact finder, right? So he's not only just acting as the judge making the legal conclusion.
Boy, I'm good. Did I not say that earlier? That Judge Krupp is actually the fact finder. This guy's really trying to fight to keep a man in prison. And this case was probably held together with friggin' duct tape.
He's acting as the fact finder. And the fact finder, we tell juries all the time, you can credit some of the things that a witness says, other things a witness says, or you can discredit all the things that a witness has said. So can't we just, is that a reasonable inference that if for this purpose of this issue, that he credited that if the defendant had this information, that it would have given him at least impeachment value that might have swayed the only key eyewitness for the government in this case?
No, it is not, Your Honor, because the witness says contradictory things. So if you credit the witness's testimony, implicitly all of it, you've credited two contradictory things. This witness is saying, my opinion is X, and my opinion X is based on my speculation. So if you say I credit the witness, what are you crediting? X, or that it's speculation? So the judge here had an obligation to actually find relevant facts that would have established any of these potential medical conditions, actually bore on her ability to be a witness. He did not do so. Legal error. Now, even if you were to say that he hadn't committed a second legal error there, then we go to the third question, whether these witnesses would be allowed to testify. They would not. I've already gone through some of Franklin's admissions about things. Then if you look at the other witness, Kleonsky, she also admitted that she never met Annis. She never reviewed any brain images. She acknowledged that the medical records showed nothing about hallucinations, memory loss, confusion, or disorientation. She admits she never even reviewed the 18A report from the doctor that treated Annis while she was at Taunton Hospital. So she never met with them. She never even looked at the documents from the doctors that did meet with her. And then she also went so far as to say Annis was clearly having a psychotic episode when she observed this murder take place in front of her. Her basis for the psychotic episode was that she found her testimony of what she saw to be so outlandish and so improbable. If you read the testimony of the officer that responded, the first responder, what their description of what they did is almost exactly what Annis said she saw. And now this expert is saying that equates to a psychotic episode. It's simply not a psychotic episode. Her opinion is worth nothing. So these witnesses would not have even been allowed to testify at a trial.
I'll ask you a basic factual or foundational question.
Sure.
If the evidence that you adduce in terms of prosecuting your motion for a new trial, does that mean that's the only people that the defendant could call at the time of trial?
No, it certainly doesn't. But, Your Honor, the defendant, when filing a motion for a new trial, has the obligation to establish any facts outside of the record. Here, what they proffered is not admissible. So they established no facts. So there's no basis on which to allow the motion for new trial. It's a fundamental misunderstanding by the motion judge about his role in evaluating a motion for new trial. He doesn't get to speculate about things. He has to see what the defendant proved and if that meets their burden. Any facts outside of the record, the defendant has to prove. Here, their experts would not have been allowed to testify at a trial. They proved nothing.
Well, I guess it goes also to the issue of the Brady violation. So is the Commonwealth contending that, again, at the time of a motion for a new trial, that the showing that the defendant has to make has to also meet the evidentiary standard at trial? I don't, and if you're contending that, what's your legal support for that?
Well, so, Your Honor, I point you to Barry. The defendant has to establish that the thing was in the prosecutor's care, custody, or control, that it was not produced, that it was in fact exculpatory, and that the resulting prejudice existed. The defendant has to prove all of those things in order to validate the finding of an error that then potentially could lead to the allowance of the motion for a new trial. So here, they didn't clear the exculpatory hurdle because, as I said before, they never should have gotten the records in the first place. If they did get the records...
So assume that we don't agree with you that it's exculpatory. I mean, I take it if you had a prosecutor call you from the trial division and said, hey, I have a Post-it note that says the key witness is in Bridgewater State Hospital. Should I turn it over? I assume that you would say, yes, you do.
Today, absolutely,
yes.
I would say that, yes.
All right. But so say we disagree with you on whether it's exculpatory. Go to prejudice. It seems to me that was in what you just ticked off, the defendant has shown, but prejudice is the issue for me.
Well, so when you reach the prejudice question here, the motion judge erred by failing to actually grapple with the strength of the Commonwealth's case. Under Pope, when you're dealing with the impact of purported impeachment material, you have to measure that impeachment material against the strength of the Commonwealth's case. And here he failed to do that at all. He basically just, the quote from his memorandum is there was not a mountain of other evidence. He didn't ever even address the fact that there was an entirely separate percipient witness that identified the defendant as the shooter in both the photographic array and at trial. He didn't even address that. He also failed to even address the defendant's admission about 2 weeks later a veiled admission to an officer.
The other witness was, I can't remember, she's a stranger witness or
It was a man, right?
Hall is his name.
Yeah,
yes, a male witness.
Timothy Hall, I think.
I'm sorry, Your Honor?
It was Timothy Hall.
I don't remember his first name, Your Honor. Mr. Hall.
But that identification, wasn't there a significant difference in what Hall said as to the size of who he perceived versus the size of the defendant?
There were slight differences, but
Right.
I would be more concerned if two witnesses described the person exactly to a T the same way. That there are slight differences is really to me no consequence.
But slight differences. He described whoever it is that Mr. Hall said he saw. He described them as being almost 270 pounds, right?
He also described the person that walked up rapping a song, and he described almost the same lyrics that Annis described.
Yeah.
And they had the same flight path away post-murder, which is where the murder weapon was actually found.
That just confirms that there was a murder. It doesn't really confirm that this defendant did it.
What we have here is two separate witnesses that both in a photographic array said, that's the shooter, and then came into court at trial and said,
to be
that's
fair and honest, Hall said 6 out of 10, maybe.
At the time of the identification.
So the point that we're trying to make here is that whether the motion judge committed a legal error in his evaluation of what was before him,
right.
He didn't even grapple with the existence of Hall, didn't even mention him, just said there wasn't any other evidence. Failed to even.
For me, I appreciate your argument on this point, but it wasn't, as I read the judge's decision, the linchpin of the reason why he allowed the motion for new trial. He didn't just peg it to the non-disclosure of the hospitalization and the resulting prejudice of not being able to pursue discovery of the medical records. There were other bases too, right? So, and that's the context that I think we look at, because the judge was looking at a series of things. And he says that the third party culprit newly discovered evidence was even more compelling, which seems to me to indicate that he prioritized that information over this component that you're focusing on. Do you want to talk about that?
Absolutely.
Like how can we disregard the judge?
Boy, oh boy. Let me stop it there for a minute. Very, very interesting. So this guy comes in, right? Like his case is airtight or something, right? He's saying that the original judge made a few mistakes, and he's saying that the defense never should have got the witnesses' psychiatric records. And even if they did, those records were not helpful. And what else is the experts who testified, they weren't legit. He was even dismissing, like the other judge said, you're dismissing the experts in this case that testified about her psychiatric conditions. And then he goes on and saying, and the other thing, he said, the judge didn't respect how strong our case was. What? So you don't want nobody looking behind the curtain is what you're saying, right? They argue that the witness being, by refusing to eat, I can't say the S word, refusing to eat, committed to a psychiatric hospital doesn't affect her ability to identify a shooter. They say that her diagnosis don't matter. The Commonwealth saying, they say that the experts were speculating, which I don't think they were speculating. They say the judge shouldn't have believed any of it. They even downplayed the second eye witness, right? The guy Hall, who said that the shooter was 270 pounds. They downplayed that as well. And the Commonwealth waves that off like it's just a typo. Then they try to minimize the DNA. You can't make this shit up. And this is what people like Eddie, was Stephen Wright, was Stephen Pina are all up against. And so many more. So many more.
judge's explanation and suddenly focused just on whether there was an error regarding the non-disclosure of information concerning the percipient witness.
So I'm happy to turn to I see that my time has expired, but I'm happy to turn to the incident report about the motor vehicle very briefly. The question there is, their claim was, again, a claim of Brady violation of a non-disclosure of two documents, the incident report about a stolen vehicle and then the stolen motor vehicle discovery form. So the only documents that are relevant here, you can find them at the appendix 285, 286, and 287. That's what we're talking about, the incident report. So in order for there to be any third-party culprit evidence there, first of all, he said it was not a Brady violation until we evaluated it as newly discovered evidence. So that's the lens we're looking at it through. But in order for that to provide any third-party culprit evidence at all, there has to be a substantial connecting link to the case. The problem is, you look at only those documents, two documents, there is no substantial connecting link. The incident report, the victim came and said, I was carjacked at 10 p.m. of my car, a four-door red Nissan at, I forget the exact street address, 31 Horden Way in Mission Hills, about 2 miles from where the murder occurred, at 10 o'clock at night.
If the timing is wrong, then this starts to become more problematic, right? Because the gun is, the murder weapon is found with one of the people, right? That seemed to be the most troubling part of that, right? The murder weapon is found with whom?
The murder weapon was abandoned near the murder scene.
Right. And it's found with the person who's associated with that report, right?
Yes, but that's not the basis of the claim here. The basis of the claim is
Yo, this fucking guy. So he's you believe that shit? Oh, don't do this to me again, this friggin' computer. Come on. So this guy is like, what the justice said was that the gun was found with who? Trying to say the gun was found in the stolen car. See, what happened was whoever stole the stolen car, right? Looks like they are the ones who allegedly committed this crime, right? And the gun was found with them, with the people that had the stolen car that were never charged for this crime, right? So now this guy is saying, but that don't matter. They probably found it. That's not the point.
Newly discovered evidence in the form of the stolen motor vehicle report.
We don't look at it in isolation, right? I mean, we look at it in the context of what the defendant knew and what value it added to the defendant's knowledge.
Completely disagree, Your Honor. The question here is whether these two documents constitute newly discovered evidence to warrant a new trial or not. They don't. There's no substantial connecting link here. Their claim was that stolen vehicle is the vehicle the murderer drove up to the murder scene in. Mm-hmm. That can't be the case if the vehicle was stolen an hour after the murder happened. Now, as to the position or the argument that there's...
Right, but it could be the case if there's an error in the report as to the time.
Well, of course. And two things that are...
So that, and then the plausibility of that is something that the judge evaluated. So it's not like the judge disregarded that point. The judge took a look at it and said, let me test this. Is there a possibility that the time was incorrect?
Yes, he did. And that was an error. The defendant's obligation is to prove facts. It's not the judge's role to speculate about possible facts. There was no proof that there was an error in the reported time. The incident report where the victim comes in and says, I was carjacked, he reported it at 10:40 and said it happened at 10 o'clock. That's Commonwealth's Appendix, page 283. That's the best report of the time. Now, the discrepancy that we're talking about here is in another form that an officer wrote down about a stolen vehicle, where it was lost and then where it's ultimately recovered. There they wrote down that the carjacking occurred at 9:30 p.m. That was an officer writing that down. The evidence of when the car was stolen is 10 o'clock. That came from the victim of the carjacking. Now, this argument about there was some confusion about it or something, or the victim didn't speak English well or something, that's wild speculation. It comes from, you can see the document at page 286 of the appendix, a note that was taken 2 years later on a phone call, where a person who received a phone call said, I struggled to understand what he was saying. That has no bearing on whether the victim was able to communicate to the officer when he reported the car as stolen and that it was carjacked. It's wild speculation. It's not the motion judge's role to speculate about the world of possible evidence. It's the motion judge's role to evaluate what was presented at the motion for new trial and find facts. You can't then allow a motion for new trial about speculated other facts. The defendant did not establish that this car was stolen before the murder so that it could have been the vehicle that the murderers drove to the scene in, because the car was stolen an hour after the murder. No substantial links, no basis for it to be admitted at trial, no basis for third-party culprit evidence, no basis to allow a motion for a new trial.
But I mean, that kind of makes sense. It was stolen an hour after, right? So now think about it. You commit this crime. You just 187 someone, you 86 someone, you take their life away. So now, look, we need to get out of here. We need a car. You carjack somebody, right? Bang, you take their car, and that's where the weapon was found with these two guys. But he's saying that Stephen Pina abandoned the weapon, and then he's assuming that these guys found the weapon.
How about the DNA?
So
that's a problem.
Respectfully,
Let's talk about the DNA. That's a problem. Same thing in Eddie's case.
Disagree, Your Honor. I mean, the motion judge himself said this is not enough to allow a motion for new trial. He said it's the absence of evidence. So if you wanted to accept his findings on it, then that's what you have to accept.
Well, I mean, he did this on a confluence kind of analysis in any event, but you're saying the other factors that went in with this absence wasn't enough.
Absolutely. And I just want to be very clear that the evidentiary hearing was limited in scope, and the DNA claims were not part of the evidentiary hearing. And it's legal error to allow a motion for new trial in the absence of an evidentiary hearing. And that's what, on this, to the extent that he argued it contributed at all into this confluence, that's legal error. They didn't put any witnesses on. There was no evidentiary hearing. The hearing was limited in scope.
But you guys agreed to that.
What was agreed before the hearing was they would let a couple of documents in.
Right, but you agreed that we didn't need an evidentiary hearing. Didn't the judge say, I'm inclined to do this on the papers, and both sides agreed that was okay?
I disagree with that characterization of the record, Your Honor. And I just point the court back to Compiano from 1995, that it is an error to allow a motion for new trial without.
What part do you disagree, though? What part do you disagree with?
That the Commonwealth agreed that there was a substantial issue raised in the DNA. And that
No, I'm talking about that the fact that there was no evidentiary component to the DNA. The judge proposed to hold that part with no evidentiary component other than the documents.
I don't have much more to say than I disagree with that characterization of what the Commonwealth's position.
What part of that do you disagree with?
That the Commonwealth didn't concede that there was a substantial issue in the DNA.
But they did say that they didn't need an evidentiary hearing to go over that.
There has to be an evidentiary hearing.
You agreed to do it on the papers. There was the report, and then the report that
This guy's getting
you
his
submitted.
ass kicked.
You did not at any point, the Commonwealth did not at any point inform the judge that it wanted an evidentiary hearing with respect to the DNA test results.
Well, I'll acknowledge that, and I'll acknowledge that the
Okay.
exhibits came in under agreement. So I'll acknowledge that. But I would just point the court back just very briefly to the judge's conclusion that the DNA material did not warrant a new trial. So thank you, Your Honor.
Thank you.
Boy, this guy was a friggin' schmuck. McLean. Hopefully he's on Eddie's case. What an idiot. So he basically comes in, right? He comes in. He says that the judge had four issues, right? One was letting the defense get the records, right? Another one, I believe I'm not mistaken, claiming that these records had impeachment value, he said the expert shouldn't qualify. The expert shouldn't have been able to testify. And he said that the judge did not respect the strength of the Commonwealth's case. Their star witness coming out of a psychiatric hospital. He tried to downplay the witness's mental health, suicide, don't matter. Refusing to eat, don't matter. But she's in the hospital. Don't matter. A psych ward. Don't matter. And the judge pushes back. They say, if your star witness is in a psych ward, how is this not relevant? And this lawyer, McLean, keeps insisting that mental illness doesn't affect perception or memory. What do y'all think about that? Mental illness doesn't affect perception or memory. Thank you, Aunt Jerry, for the $19.99. Really appreciate that. Exonerate Eddie O'Brien. Absolutely, man. I really appreciate that. Top Dog Denise says she was institutionalized in a mental hospital. That doesn't mean anything, right? Don't ever be sorry. Sorry is overrated. I don't ever want you to be sorry again. Kimberly Budd, I believe, is the... I'll point her out. I think I already did, but I could be mistaken. Where's Mr. OB at? Where's Mr. OB? It's 1 o'clock in the afternoon. He should be up. He should be up. So, yeah, he tries to downplay, the lady wouldn't eat. It wasn't relevant. Right? So, the judge ends up questioning why the motion judge didn't apply the correct protocol. And I don't know why. And I think the judge also said, why does the Commonwealth think that this person trying to end their life has no bearing on her testimony? And I think they also said to McLean, why does this expert testimony, why was it dismissed without findings? And this guy really tries to argue that the borderline personality disorders, look at me, I'm drooling. The borderline personality disorders don't affect memory. Are you fucking serious? Excuse my language, I'm sorry. But... Oh, and then he said, but the experts were speculating. Like, no, they're testifying, not speculating. And then he goes on, he continues saying that the judge made zero factual findings. It's up to the judge. He is the fact finder, just like a juror. The jury is a fact finder. In the Karen Reed case, the jury could have accepted all the facts, or they could have accepted none of the facts. None of them. And the judge keeps pointing out contradiction after contradiction in this case. I mean, this is the Commonwealth trying to hold a collapsing building together with duct tape. And this stream got all screwed up, right? So can everyone take the time right now to share it to any pages? We need to get some people up in here. And then, what did he say? I think it was in, let me see. I think it was right over here somewhere. They're talking about the eyewitness problem.
Nothing about hallucinations, memory loss, confusion, or disorientation. She admits she never even reviewed the 18A report from the doctor that treated Annis while she was at Taunton Hospital. So she never met with them. She never even looked at the documents from the doctors that did meet with her. And then she also went so far as to say Annis was clearly having a psychotic episode when she observed this murder take place in front of her. Her basis for the psychotic episode was that she found her testimony of what she saw to be so outlandish and so improbable. If you read the testimony of the officer that responded, the first responder, what their description of what they did is almost exactly what Annis said she saw. And now this expert is saying that equates to a psychotic episode. It's simply not a psychotic episode. Her opinion is worth nothing. So these witnesses would not have even been allowed to testify at a trial.
Ask you a basic factual or foundational question.
Sure.
If the evidence that you adduce in terms of prosecuting your motion for a new trial, does that mean that's the only people that the defendant could call at the time of trial?
No, it certainly doesn't. But, Your Honor, the defendant, when filing a motion for new trial, has the obligation to establish any facts outside of the record. Here, what they proffered is not admissible. So they established no facts. So there's no basis on which to allow the motion for new trial. It's a fundamental misunderstanding by the motion judge about his role in evaluating a motion for new trial. He doesn't get to speculate about things. He has to see what the defendant proved and if that meets their burden. Any facts outside of the record, the defendant has to prove. Here, their experts would not have been allowed to testify at a trial. They proved nothing.
Well, I guess it goes also to the issue of the Brady violation. So is the Commonwealth contending that, again, at the time of a motion for a new trial, that the showing that the defendant has to make has to also meet the evidentiary standard at trial? I don't, and if you're contending that, what's your legal support for that?
Well, the judge is basically saying, I ain't buying it. I'm not buying it.
Well, so, Your Honor, I point you to Barry. The defendant has to establish that the thing was in the prosecutor's care, custody, or control, that it was not produced, that it was in fact exculpatory, and that the resulting prejudice existed. The defendant has to prove all of those things in order to validate the finding of an error that then potentially could lead to the allowance of the motion for new trial. So here, they didn't clear the exculpatory hurdle because, as I said before, they never should have gotten the records in the first place. If they did get the records...
Assume that we don't agree with you that it's exculpatory. I mean, I take it if you had a prosecutor call you from the trial division and said, hey, I have a Post-it note that says the key witness is in Bridgewater State Hospital. Should I turn it over? I assume that you would say, yes, you do.
Today? Absolutely,
yes.
I would say that. Yes.
All right.
Today, I would. How about yesterday? You shouldn't turn something like that over back in 1996. And I bet he wouldn't have turned it over, just like Riley didn't turn over the serology testing, just like Riley didn't turn over the DNA paperwork.
So say we disagree with you on whether it's exculpatory. Go to prejudice. Because it seems to me that was in what you just ticked off, the defendant has shown, but prejudice is the issue for me.
Well, so when you reach the prejudice question here, the motion judge erred by failing to actually grapple with the strength of the Commonwealth's case. Under Pope, when you're dealing with the impact of purported impeachment material, you have to measure that impeachment material against the strength of the Commonwealth's case. And here he failed to do that at all. He basically just, the quote from his memorandum is, there was not a mountain of other evidence.
The judge
didn't ever even address the fact that there was an entirely separate percipient witness that identified the defendant as the shooter in both the photographic array and at trial. He didn't even address that. He also failed to even address the defendant's admission about 2 weeks later, a veiled admission to an officer.
The other witness was, I can't remember, she's a stranger witness or
It was a man, right?
Hall is his name.
Yeah,
Yes, male witness.
Timothy Hall, I think.
I'm sorry, Your Honor?
Or it was Timothy Hall.
I don't remember his first name, Your Honor. Mr. Hall.
But that identification, wasn't there a significant difference in what Hall said as to the size of who he perceived versus the size of the defendant?
There were slight differences, but
right.
Yes. I think he said that it was like a 270-pound shooter is a slight difference. And I think he said it's 6 out of... Oh, and that's the other thing. He said, I'm 60% positive it's Steve Pina. I'm 60% sure. I'm 6 out of 10 identification. That's still valid? Imagine that. 6 out of 10, you know... How sure are you? Like a 6.
I would be more concerned if two witnesses described the person exactly to a T the same way. That there are slight differences is really to me no consequence.
But slight differences. He described whoever it is that Mr. Hall said he saw. He described them as being almost 270 pounds, right?
He also described the person that walked up rapping a song, and he described almost the same lyrics that Annis described.
Yeah.
And they had the same flight path away post-murder, which is where the murder weapon was actually found.
That just confirms that there was a murder. It doesn't really confirm that this defendant
That it was done by Pina.
What we have here is two separate witnesses that both in a photograph array said, that's the shooter, and then came into court at trial and said,
to be
that's
fair
the
and
shooter. 6 out of 10.
honest, Hall said 6 out of 10, maybe.
Thank you.
At the
See, I'm bringing all this shit up. Like, he described that the shooter was 270 pounds. And 6 out of 10 is pretty serious. I'm trying to see what her nameplate says.
time of the identification.
So the point that we're trying to make here is that the motion judge, whether the motion judge committed a legal error in his evaluation of what was before him,
Right.
he didn't even grapple with the existence of Hall, didn't even mention him, just said there wasn't any other evidence. Failed to even.
For me, I appreciate your argument on this point, but it wasn't, as I read the judge's decision, the linchpin of the reason why he allowed the motion for new trial. He didn't just peg it to the non-disclosure of the hospitalization and the resulting prejudice of not being able to pursue discovery of the medical records. There were other bases too, right? So, and that's the context that I think we look at, because the judge was looking at a series of things. And he says that the third party culprit newly discovered evidence was even more compelling, which seems to me to indicate that he prioritized that information over this component that you're focusing on. Do you want to talk about that?
Absolutely.
Like how can we disregard the judge's explanation and suddenly focus just on whether there was an error regarding the non-disclosure of information?
Yeah, because this guy, I think he argued that the stolen car report isn't even connected.
Concerning the percipient witness.
So I'm happy to turn to I see that my time has expired, but I'm happy to turn to the incident report about the motor vehicle very briefly. The question there is, their claim was, again, a claim of Brady violation of a non-disclosure of two documents, the incident report about a stolen vehicle and then the stolen motor vehicle discovery form. So the only documents that are relevant here, you can find them at the appendix at 285, 286, and 287. That's what we're talking about, the incident report. So in order for there to be any third-party culprit evidence there, first of all, he said it was not a Brady violation until we have evaluated as newly discovered evidence. So that's the lens we're looking at it through. But in order for that to provide any third-party culprit evidence at all, there has to be a substantial connecting link to the case. The problem is, you look at only those documents, two documents, there is no substantial connecting link. The incident report, the victim came and said, I was carjacked at 10 p.m. of my car, a four-door red Nissan at, I forget the exact street address, 31 Horden Way in Mission Hills, about 2 miles from where the murder at 10 o'clock at night.
If the timing is wrong, then this starts to become more problematic, right? Because
More problematic for the Commonwealth if the timing's wrong. But this guy's going to say, oh, it's speculation, just like he tried to minimize the damn DNA.
that the gun is, the murder weapon is found with one of the people, right? That seemed to be the most.
That's crazy that the weapon's found with one of the people. And listen to this friggin' idiot lawyer, man. Listen to what he says. Shout out to Maddie over there at the W Number Podcast also. We're going to go back and check out a couple of his clips right after this.
Troubling part of that, right? The murder weapon is found with whom?
The murder weapon was abandoned near the murder scene.
Right. And it's found with the person who's associated with that report, right?
Yes, but that's
Yes. So the murder weapon's found with the people that stole the car. So one witness says Stephen Pina. He said, I'm 6 out of 10 that it's Stephen Pina. This other lady was just all junked out. You know what I mean? Like,
that's not the basis of the claim here. The basis of the claim is newly discovered evidence in the form of the stolen motor vehicle report.
We don't look at it in isolation, right? I mean, we look at it in the context of what the defendant knew and what value it added to the defendant's knowledge.
Completely disagree, Your Honor. The question here is whether these two documents constitute newly discovered evidence to warrant a new trial or not. They don't.
Yeah, all right, buddy. I'm sure you do disagree.
There's no substantial connecting link here. Their claim was that stolen vehicle is the vehicle the murderer drove up to the murder scene in. That can't be the case if the vehicle was stolen an hour after the murder happened. Now, as to the position or the argument that there's...
But it could be the case if there's an error in the report as to the time.
Well, of course. And two things that are
so that, and then the plausibility of that is something that the judge evaluated. So it's not like the judge disregarded that point. The judge took a look at it and said, let me test this. Is there a possibility that the time was incorrect?
Yes, he did. And that was an error. The defendant's obligation is to prove facts. It's not the judge's role to speculate about possible facts. There was no proof that there was an error in the reported time. The incident report where the victim comes in and says, I was carjacked. He reported it at 10:40 and said it happened at 10 o'clock. That's Commonwealth's Appendix, page 283. That's the best report of the time. Now, the discrepancy that we're talking about here is in another form that an officer wrote down about a stolen vehicle, where it was lost and then where it's ultimately recovered. There, they wrote down that the carjacking occurred at 9:30 p.m. That was an officer writing that down. The evidence of when the car was stolen is 10 o'clock. That came from the victim of the carjacking. Now, this argument about there was some confusion about it or something, or the victim didn't speak English well or something, that's wild.
Is this Karen Reed right here? That looks like Karen Reed, right?
Speculation. It comes from, you can see the document at page 286 of the appendix, a note that was taken 2 years later on a phone call where a person who received a phone call said, I struggled to understand what he was saying. That has no bearing on whether the victim was able to communicate to the officer when he reported the car as stolen and that it was carjacked. It's wild speculation. It's not the motion judge's role to speculate about the world of possible evidence. It's the motion judge's role to evaluate what was presented at the motion for new trial and find facts. You can't then allow a motion for new trial about speculated other facts. The defendant did not establish that this car was stolen before the murder so that it could have been the vehicle that the murderers drove to the scene in, because the car was stolen an hour after the murder. No substantial links, no basis for it to be admitted at trial, no basis for third-party culprit evidence, no basis to allow a motion for new trial.
How about the DNA?
Oh, yeah, the DNA, he tries to minimize that too. You know what I mean? And I think the judge is going to tell him, you agreed to submit DNA on paper. And then watch this guy. He's probably at that point, he's like, I'm done. I fold. I'm out of here.
So
that's a problem.
I respectfully disagree, Your Honor. I mean, the motion judge himself said this is not enough to allow a motion for new trial. He said it's the absence of evidence. So if you wanted to accept his findings on it, then that's what you have to accept.
Well, I mean, he did this on a confluence kind of analysis in any event, but you're saying the other factors that went in with this absence wasn't enough.
Absolutely. Absolutely. And I just want to be very clear that the evidentiary hearing was limited in scope, and the DNA claims were not part of the evidentiary hearing. And it's legal error to allow a motion for new trial in the absence of an evidentiary hearing. And that's what, on this, to the extent that he argued it contributed at all into this confluence, that's legal error. They didn't put any witnesses on. There was no evidentiary hearing. The hearing was limited in scope.
But you guys agreed to that.
What was agreed before the hearing was they would let a couple of documents in.
Right, but you agreed that we didn't need an evidentiary hearing. Didn't the judge say, I'm inclined to do this on the papers, and both sides agreed that that was okay?
I disagree with that characterization of the record, Your Honor. And I would just point the court back to Compiano from 1995, that it is an error to allow a motion for new trial without.
What part do you disagree, though? What part do you disagree with?
That the Commonwealth agreed that there was a substantial issue raised in the DNA, and that
No, I'm talking about the fact that there was no evidentiary component to the DNA consideration, that the Commonwealth agreed with the way the judge proposed to hold that part with no evidentiary component other than the documents.
Your Honor, I don't have much more to say than I disagree with that characterization of what the Commonwealth's position.
What part of that do you disagree with?
That the Commonwealth didn't concede that there was a substantial issue in the DNA.
But they did say that they didn't need an evidentiary hearing to go over that.
There has to be an evidentiary hearing.
You agreed to do it on the papers. There was the report and then a report that you submitted. You did not at any point, the Commonwealth did not at any point inform the judge that it wanted an evidentiary hearing with respect to the DNA test results.
Well, I'll acknowledge that, and I'll acknowledge that the
Okay.
exhibits came in under agreement. So I'll acknowledge that. But I would just point the court back just very briefly to the judge's conclusion that the DNA material did not warrant a new trial. So thank you, Your Honor.
Thank you.
They laughed at him. It was like, buddy, enough. Plus, he went like 7 minutes over. They were like, enough. So now we're going to see the defense attorney, Tessia, that's going to open up. And Tessia is going to tell you the truth, how Stephen served 28 years on a wrongful conviction. And let's see how she lays out her issues. Because this guy just was, he was horrible. He was horrible.
Okay, Attorney Tessier.
Oof. Can I take a quick break? Oh, shout out to JoJo. Shout out to JoJo. What up, JoJo? Which one of these maggots is Bud? JoJo, do you know? It's either this one, or this one. I don't think it. Oh, it might be this one because she's the Chief Justice, right? So she's probably in the middle. So now, the jury never heard evidence pointing to these two other men. I think they named Brian Johnson and something Woods. So she lists what the jury never knew. So let's see what Ms. Tessia has to say.
Good morning, and may it please the court. Jill Tessier, with me at counsel table is Attorney Lisa Kavanaugh, on behalf of Stephen Pina, who is present here today. Mr. Pina was released from prison 4 years ago as of March 9th, after serving 28 years on this wrongful conviction. The only issue before this court is whether the motion judge abused his discretion in finding that justice was not done when the jury was deprived of hearing compelling evidence pointing to Brian Johnson and Anthony Woods as third-party culprits. Modern eyewitness identification science undermining the reliability of the identifications made by both Annis and Hall. Expert testimony showing that a key witness, Annis, suffered from long-standing psychiatric and a psychiatric illness and substance use issues that likely impaired her ability to accurately perceive, recall, and reliably identify the perpetrator, and modern DNA analysis excluding Mr. Pina from relevant areas of the murder weapon and the victim's clothing. Judge Krupp's careful, well-reasoned decision falls well within the range of reasonable alternatives, and there is no basis to disturb it. Judge Krupp's decision should be affirmed on the third-party culprit issue alone. We now have compelling, substantial connecting links that demonstrate that Mr. Pina was deprived of a significant third-party culprit in Bowdoin defenses that would have been real factors in the jury's deliberations. The jury did not hear that Brian Johnson, a person who stole the murder weapon from his father in the weeks leading up to the murder, bore a scar in the same location as a bleeding wound observed on one of the Annunciation Road robbery victims who refused medical attention or police help and said to the police, "Don't worry, I'll take care of it myself," mere hours before the murder. The jury did not hear that Johnson and Anthony Woods, a person who fit the description of the shooter, were arrested 2 weeks after the murder in a vehicle that was stolen at gunpoint on the night of the murder and that matched descriptions of the shooter's car. As the Commonwealth previously asserted and the motion judge found, it defies logic that these are mere coincidences. And defense counsel was on to something on this end, but he lacked the evidence necessary to tie it all together for the jury. evidence that would have supported an argument to the jury that a person who stole the gun before the murder was also the victim of the Annunciation Road robbery, that the Annunciation Road robber was Keith Robinson, that the person who stole the gun was arrested 2 weeks later in a car that matched the description of that used in the shooting with a person who matched the description of the shooter. All the jury heard at trial was that the Annunciation Road robber and Robinson were both wearing red colored jackets.
So the victim, Keith Robinson, ended up robbing these guys and they went back for revenge. And the fact that they were arrested 2 weeks later in the car with the weapon.
That the description of the Annunciation Road robber was close to that of Robinson's appearance, and that housing officers had initially suspected a link between the two incidents, but by the time of trial had completely disavowed this. The prosecutor on the other, I'm sorry, Your Honor. The prosecutor on the other hand argued vigorously to the jury that there was no connection between the two incidents and that the red jacket had absolutely nothing to do with the murder. Counsel also tried to get in evidence through cross-examination of
I want to stop that for a minute because I like what this fine gentleman said. Look at this guy in the suit. Who is this guy? He said, these people actually believe, knowing he's been wronged, he should stay in jail because of human error. Knowing it couldn't have happened, it couldn't have even been him, he should stay in jail. 666, this is what you're up against. But you know what? Joe? At least they're gonna make it right? At least the SJC is gonna make it right. And hopefully what Eddie goes in there with, a lot of stuff is similar to DNA. You just can't argue with a lot of this shit.
Detective McCarthy, evidence regarding Robert Grady, the owner of the gun, his son Brian Johnson, who stole the gun before the murder, in order to show that the police never thoroughly investigated Johnson's connection to the gun. But the Commonwealth moved to strike, the judge agreed, and the jury heard none of this. And even though Judge Krupp analyzed this as newly discovered evidence, all of this is set upon the backdrop of what we know now, that the Commonwealth itself had some reason to suspect something about Johnson and Woods because there were 25 pages about both of them contained within the trial prosecutor's trial file, tracking the progress of their cases related to the arrest in the maroon Nissan. The Boston Police homicide file had their arrest reports in their file for this very murder.
So the difficult part of this case is that Judge Krupp, there wasn't any single thing that was dispositive here. He's doing this kind of cumulative analysis under Rule 30. And so that makes it really hard to kind of just parse this out and say which one's weighted which way. So let's just focus on the car. How do you respond to the Commonwealth's argument about the timeliness issue? Because the best evidence, and I'm not using it in an evidentiary sense, I'm just saying the best evidence of when that car was stolen was the own first party report of the person whose car got carjacked. And that person puts that carjacking before the time of the murder.
Sure, Your Honor, I'd be happy to address that. So I think it's first important to note that the carjacking victim, Mr. Thelismond, did not report the carjacking to the police until the following morning. So it was actually not 10:40 p.m. that night, it was 10:40 the following day. And of course, as Justice Wolahojian acknowledged, there could be errors in transcribing the reports. And in fact, the reports were internally inconsistent. One said 10 p.m., one said 9:30. But the fact of the matter is that there was no concurrent external record of when the carjacking occurred because Mr. Thelismond did not call the police. So we don't have a 911 tape to verify when the vehicle was stolen. We don't have a CAD sheet or any sort of dispatch log to tell us more reliably when the vehicle was stolen. And I think the greater point of all of this is that you have to consider the issue of when the car was stolen in the context of all of the substantial connecting links. And that goes to the weight of the evidence, not the admissibility. So the Commonwealth could argue whatever inference they want the jury to draw from the timestamp notations. But the problem is the jury didn't hear any of this. And that's where the real issue lies.
You talk about the psychiatric records.
Sure.
In light of all of the kind of warts to them, how would the psychiatric records have been used at trial?
Sure. So this court has long held that evidence relating to a person's substance use or mental health is admissible as impeachment evidence as long as there's a link between that and the person's ability to accurately perceive and recall and testify. At the time of trial, Mr. Pina would have consulted with an expert like he did here with Dr. Kleonsky, who would have been able to explain to the jury how her long history of substance use disorder, which dated back to her adolescence, and her diagnosis of borderline personality disorder, how studies support that those diagnoses fundamentally alter the cellular makeup of the brain. And she went into great detail explaining how each of those diagnoses affects different parts of the brain in ways that I'm not qualified to.
Is it Kleonsky or Franklin who says that there's no peer support for their conclusion?
That's not what they said.
Okay, well, the one that has the problem.
Sure. So Dr. Kleonsky is the psychiatrist who testified about the records from a medical perspective. Dr. Franklin testified from the perspective of an eyewitness identification expert. And she testified about her review of studies of relating to people who are known to have borderline personality disorder and the impacts of that disease on cognition and memory, which is in her field of cognitive psychology. So she testified about a subset of her field, which is eyewitness identification evidence. And she testified that the factors that this court has generally accepted, the studies assess them using a baseline typical person, right? Because it would be difficult to just pick particular people who have certain diagnoses in order to conduct these laboratory tests. And that the hallmarks of borderline personality disorder, as she understands them from the research that's conducted on them from her field, is that one of the hallmarks is this increased stress response for people who have borderline personality disorder. And she talked about how this would essentially enhance the effects of the underlying estimator variables of stress and potentially weapons focus, because those are really assessed on typical people with no mental health or substance use conditions. And we know that stress is a huge factor, and that's counterintuitive.
That's conflating the new science of eyewitness testimony with this, which didn't exist back then, right?
Sure.
So let me ask you, how was the witness impeached at trial?
How did it actually happen at trial?
Right.
So defense counsel cross-examined her on her inconsistent statements, which she made several. Her statements were inconsistent as to her memory and observations of the immediate aftermath of the event. So for example, she told the jury that she went and remained by Mr. Robinson's side until he was loaded into the ambulance, yet first responders testified that they never saw her there and that she wouldn't have been allowed within that perimeter because they
What about her substance use?
In terms of her substance use, well, this is part of the problem, Your Honor. Defense counsel tried in earnest to cross-examine Ms. Annis on her substance use history, which he proffered to the judge would go directly to her ability to accurately perceive and recall events. But as to every single question, the prosecutor objected, and the judge agreed. And the only thing that counsel was able to ask about was whether she was using drugs on the night of the murder and whether she was using drugs on the night of the identification procedure. So that's fundamentally different than what the jury would be able to hear now, knowing what we know about her.
Right. So then that leads to the inquiry of the case law that we have that says that mere impeachment evidence, usually the discovery of impeachment evidence, usually isn't enough to sustain a motion for new trial. How do you address those cases?
Well, the court has never held a broad prohibition against the use of impeachment evidence being used in a trial.
We usually have to say it's blockbuster impeachment. I mean, I forget the name of the case. But, you probably remember it. Justice Link wrote it, but anyway.
Well, sure. So I think here we have a witness who is the primary witness at trial. So the jury believing her is a really important piece of what happens with the verdict. And in fact, the SJC decision, the entire fact section is framed on Annis's testimony. So we know her testimony was important. She's an eyewitness. There's no physical or forensic evidence connecting Mr. Pina to the crime. So that makes her testimony even more important. So discrediting her was pivotal, was critical to Mr. Pina's defense. There was no other way for him to mount a defense in this case, other than, presenting a third-party culprit defense, in order to challenge her identification and her reliability as a witness. So I think this is one of those blockbuster things when a conviction is based primarily on her testimony.
Is it though? Because in the universe of impeachment devices, the one that was used actually at trial was a prior inconsistent statement. So it's not character, but you get to argue that this witness has said different things at different times about something that's really important versus the speculation that this person there's a theoretical person who, if they have this borderline personality disorder, might have a problem in their perception and memory and all of this other theoretical conceptual stuff versus the concrete at different times, at different places. This witness said something different.
Sure. And what the expert testimony would do is provide additional context for why those inconsistencies might be happening. And it would have allowed the jury to credit, to whatever extent they wanted to, an expert's testimony explaining how these might just not be mistakes. These might be attributed to a faulty memory. And that, I think, it provides an overall context to the inconsistent statements that the jury wasn't able to hear and that the prosecutor wouldn't have been able to easily explain away. I think sort of going back to the identifications and tying it to the third-party culprit evidence, the third-party culprit evidence is especially important where it points to a person who matched the description of the shooter. And that would have been even more important in the context of an eyewitness identification. And at the time of trial, the jury did not have the benefit of the eyewitness identification science that this court has now held constitutes newly discovered evidence in Gaines and Mercado. And because of this, the jury didn't have the tools to evaluate the reliability of the identifications made by both Miss Annis and Hall. And critically, the jury didn't hear expert evidence that would have allowed them to understand that Annis's claimed familiarity with Mr. Pina didn't insulate her from making a misidentification. So Dr. Franklin testified that true familiarity lies in people who are close friends or family members, and strangers lie at one end of a spectrum. That familiarity lies on a spectrum, and there's this gray area in the middle, and that's where Miss Annis's purported familiarity lies, and that's where errors occur. And this court has recognized that because in the jury instructions, including the ones that were just approved on February 18th, there's a specific instruction that asks the jury to consider whether or not the witness is a family member, a close friend, or a longtime acquaintance. And there's a long footnote 11, which cites to a string cite of research that tracks the testimony of Dr. Franklin with regards to this issue of familiarity. So in terms of newly available scientific evidence, the jury was deprived of hearing evidence that relates to her claimed familiarity. The Commonwealth continues to use her purported familiarity as a shield to any attack on the identification evidence, but that shield is not impenetrable. And that's the problem here. The jury didn't have the tools to understand that. The jury didn't hear expert testimony explaining that both Annis and Hall's initial non-identifications, and I do consider Hall's 6 out of 10 or 60% a non-identification, and this court has said that that type of...
When Hall said, I'm 60% sure it was him. It's like I got two Powerball. I got 2 numbers on a Powerball. I'm 60% sure it's him. And then the defense tries to cross-examine Johnson, and then the Commonwealth objects, and the judge struck the questions down, and the jury, like in Eddie's case, heard none of it.
Unequivocal identification is unreliable inherently. We're diagnostic of innocence. The court didn't hear expert testimony explaining how the numerous estimator variables that increase the risk of misidentification by both Hall and Annis affected the reliability of her identifications. And there's no question that this would have been a real factor in the jury's deliberations, especially where there are already numerous inconsistencies in the eyewitness.
But that focuses on this one piece, and I go back to why this case is so hard. Judge Krupp is making this cumulative kind of analysis under Rule 30. And, you heard some of the limitations particularly with the impeachment evidence and the jurisprudence that we have that Justice Gaziano went through with you. So what are the limits on this? What are the limits on kind of relief under Rule 30 in this kind of cumulative context? I mean, you're always going to have a bunch of these factors. And so what's going to be the limiting principle here to the finality of decisions and verdicts?
Well, this court has been very clear in cases like Brescia, Epps, Rosario, Ellis, that when there's this confluence of factors that considered together make it clear that justice may not have been done, that specific standards have to yield to the underlying principle of Rule 30, which is the touchstone must be to do justice. And in this case, where we have a third-party culprit issue, where we have new eyewitness identification science, where we have expert testimony indicating that there may have been psychiatric and substance use diagnoses about one of the key witnesses that could have provided important context to her testimony, and where there's favorable DNA results, all of those things together create a perfect storm of injustice here, and I think very firmly demonstrate that it was not an abuse of discretion for Judge Krupp to find that justice may not have been done in this case.
Yeah, let me go over and get one. Do you all have a thank you. I will take that. Okay. You just want to sit anywhere on the sidewalk.
What happened? What happened here? Well, let me see what happened there. But what y'all think about that? You know, the defense tried to cross-examine Johnson. The Commonwealth objects to it. You know, what was crazy, though, that the science, what the jury never heard. And you heard, what is it, Tessia? You know, talking about that, how the stress destroys the memory, the borderline personality disorders, increase misidentification cases. How about the substance abuse? That affects your perception. You know, and then Hall, 6 out of 10 is non-identification. You know, like basically I'm 60%. I'm 60% good on this. You know, 60% good, huh? You know, I said, I'm 60% good.
Identification science that this court has now held constitutes newly discovered evidence in Gaines and Mercado. And because of this, the jury didn't have the tools to evaluate the reliability of the identifications made by both Miss Annis and Hall. And critically, the jury didn't hear expert evidence that would have allowed them to understand that Annis's claimed familiarity with Mr. Pina didn't insulate her from making a misidentification. So Dr. Franklin testified that true familiarity lies in people who are close friends or family members, and strangers lie at one end of a spectrum. That familiarity lies on a spectrum. And
so the jury didn't have the tools to evaluate the reliability, and Tessie is basically saying that Annis's mental health issues, her inconsistency statements, I believe, substance abuse history came into this, hospitalization. You know, the fact that that she had the idea of ending her life. And all that stuff was blocked at trial. And then you look at the DNA, how it excluded Pina from the weapon, huh? Does that sound like Eddie? How about the DNA excluded Pina from the victim's clothing? I mean, the jury never heard any of that. And that basically ends up becoming the perfect storm, I think. Like Tessia delivers the line that just stops every justice was not done. Not one mistake, not one witness, not one oversight. She said a confluence, a perfect storm. And it was a perfect storm. If you think about it, the third party suspects, the psychiatric things, eyewitness science people, right? The DNA exclusions. Stop me when I'm wrong. And I don't know why people are not coming in here. I have no friggin' idea. I'm going to have to pause this and check it out. The police notes that were hidden, more things that kind of make it similar to the Eddie O'Brien case. Yeah, a jury that's just flying blind. Another comparison to the Eddie Bryan case. Judge Krupp's decision sounds like it was correct, people. And now you got the Commonwealth that tried to defend, right, a collapsing case. And the defense showed the judges every brick that was missing. Every brick. Every brick that was missing, they basically showed you.
Right there was like almost the beginning of your sentence. It affected you in such a way you felt like you needed to have.
Why does he keep doing this shit to me today? Damn, gee, what the hell? Yeah, right? It is all crazy. The whole thing, what he said, it's all crazy. You know, it's all crazy. Tell me something else. Oh, I thought you all had this on screen. Damn. He said, it's all crazy. Tell me something else. You know, if they get to mold the witnesses in a shape that they want, the witnesses isn't the person who they are at the time of the crime. The jury has only the version the government has shaped them into. No, it's all good. It's all good. The justice system actually does suck. Absolutely. But this was right here. This was very, very good. What Maddie did.
Right? They hooked me and this dude up together. You know how he like this, bro.
Yo, no way. That's what they do in Nashville to everybody. That's crazy.
Bro, we're hooked up together, right next to each other, bro. Right?
That's nuts.
Again, he don't know who I am, but I know who he is.
Yeah.
So I'm like, oh shit, nigga. Like they done put us. We get to the big holding tank. The guards realize we ain't supposed to be in a tank together.
Yeah.
So they call his name. He leaves, and this man is like, yo, what's up? Boo, 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 boo. And he was like, nah, they put me over here. So everybody's like, yo. And I tell this man, I was like, yo, he's here to testify against me.
Really?
That's what they were bringing him there for.
What?
So the man that supposedly saw the shooting go down didn't identify him when they were shackled up together. Didn't even identify him when he went to get the buffer. Right? And then I think later on admits that Pina wasn't the shooter.
So
that's crazy.
What happens is they come down and get him because they put him on another side. They come down and get him. They bring him wherever upstairs. And I want to say 15 minutes later, they bring him back downstairs. Right?
Yeah.
So his man is like, yo, what happened? And he was like, yeah, they showed me this picture of this dude, man, talking about this is the guy that ain't him. I don't know why I already told him I didn't want to be involved. That wasn't the guy. So I'm hearing the dude is translating to me because they're talking, he's telling me what's up.
Yeah.
I'm like, what's up? I send my attorney, like, yo, go talk.
Damn, imagine that you in court and you hear all this because it's big, you know, you could hear shit echoing in the holding cell. And he's like, the man said was like, I didn't want no part of it. I told him it's not this dude. So the man that saw the shooting go down didn't notice him when he went to get the buffer, didn't notice him when they were shackled next to each other. Right? That's some crazy shit.
Talk to him. The attorney's like, yeah, I don't want to, you know, let me, you know what I'm saying? So the attorney, like, talked to him, but didn't talk to him. Didn't go and ask the right question. You know how that goes.
Yeah.
Get convicted. You know, I go to Concord for like a day or two. Then I'm shipped to Walpole. I'm at Walpole.
Wow, and this was during his trial when he's saying, yo, I told him it wasn't him. That's crazy. And he goes to Walpole, gets his W number, because the W number, I learned this from Big Ed O'Brien, that means you was in Walpole.
You were only at Concord for a day or two?
Yeah.
Wow, that's crazy.
Because they were like, oh, you got to, yeah, they was.
But Eddie O'Brien was only in Concord for a day or two, right?
Like, oh, you got a first degree sentence. You got to get you out of here. Right.
Nah, same thing as Eddie, right? First degree sentence. So he said he was in Concord for only a day or two, but because of his sentence, they had to get him out of the facility. And my other timestamp is like 47. I don't want to show you the whole thing. I want you to go watch it. Go to Maddie's channel, the W Number Podcast, and go check it out. I'm just showing you, this next segment we're going to watch is like basically, the evidence that was withheld. So the dude that had the motive, had the opportunity, had the weapon, was never investigated. And the police report showed that they were withheld. I mean, this guy's information was in Pina's file.
The jacket on. They look at this guy. He was with another guy, and they was like, "Do you want to fill out a police report? What's your name?" He's like, "Nah, fuck that. I'll handle it myself later."
Word. Police. Oh, dude, I'll
right?
That's another argument.
So now this is the guy that he just seen. He was like, "Nah, I'll take care of it myself later."
That's another thing.
Housing cops, James O'Laughlin and Yvonne Michelle.
Punks.
3 hours later, they get to the homicide scene and they realize the guy laying on the ground is the same guy that ran in the building.
Oh, shit.
Right? So from that police report alone, where you have a guy saying, "Fuck it, I'll handle myself later." Which we find out.
You know why they could have went after you, bro? Is because they would have looked like fucking fools if that came out.
Again, it was brought. We found out later. So
32 years of your fucking life because they did some stupid shit and let something happen.
So now there's a car stolen, carjacked.
Clip that.
Right?
That's crazy.
There's a car carjacked that night before the homicide.
And this is where he ties in the people that stole the car. It's just crazy.
Now, let me put this in perspective. 2 weeks after the homicide, the kid who stole the gun from his dad.
Yeah.
Right?
Yeah.
Now, remember I said the guy was bleeding from the eye.
Mm-hmm.
2 weeks later, this guy who stole the gun from his dad is arrested in that car with another guy who kind of looks like me.
Wow. Yeah.
He's got fresh stitches above his eye.
Yup.
So you got the guy who stole the gun from his dad that was used in the homicide, has fresh stitches above his eye from an earlier robbery that somebody bust his eye, where this guy with the bleeding eye says, "Fuck it, I'll take care of it myself later." 3 hours later, that guy is dead. This guy who is in a car that fits the description of the car that the shooter got out of and drove away in, or the shooter got out of and that car ended up driving away, is found in that car.
Wow. Yeah, go over there and check out Maddie and check out Stephen Pina. Great interview over on the W Number Podcast. Hope I broke this down for y'all. Yes, the justice system sucks. Absolutely. The witness said the shooter was the same height as the Vic, right? So the dude's, his head split open. Couple hours later, the dude that busted his eye open is on the ground, 86th. He's done. And now you have Stephen Pina that's being hauled away to start his 30-some-odd years wrongful conviction. And it was both on some bullshit evidence, prosecutorial misconduct. The system is biased, man. But you know what? Stephen's exoneration now, I think, is both a personal victory, and it's definitely a painful friggin' reminder, right? It's a painful reminder. My internet got all screwed up today. I don't know how there's only been 5 people here all day, which kind of don't make no friggin' sense. But you get 100 people to go see these friggin' idiots. I don't get it. I don't get it, man. It disgusts me at times. It definitely disgusts me at times. But yeah, go over there and check out the the W Number Podcast. I don't know. I got disgusted, but yeah, go over there and check that out. Maddie did a great job with Stephen Pina. I hope I was able to break that down. I just wanted you to see, what the SJC hearing was like, yeah, man, shout out to Stephen, shout out to Maddie at the W Number Podcast. I'm not seeing comments of the mic. It's not just you. Yeah, I don't know what the hell it is. Yeah, it was a very good interview. Maddie done a great job. You know what I mean? Yeah, look, it's only like, yeah, Maddie done a really good job. Appreciate everybody that, look at that, huh? How 2 cents worth has been a member for 3 months, man. Thank you. I really appreciate that. I was going through the memberships earlier, looking at the memberships, man. Denise really hooked us up the other day, with like 75 new members, man. Thank you. I really appreciate that. Yeah, it's been a tough month, man. It's gonna be even tougher month. Now that the fall weather's coming, so but maybe this winter I could just dig in the house and we could podcast all day, every day, and we could talk about a lot of these cases, because I don't know, man. My contract's coming up at work, so I might have no choice but to come do this podcast stuff, because if they don't renew my contract, then I'm asked out. But no, absolutely, man. Maddie did a great job. But imagine this, that you've got the 2 other guys, right? Brian Johnson and Anthony Woods. They're arrested 2 weeks after the crime in a stolen car that matched the description of the shooter's vehicle, right? Remember, for 3 months. That's what I'm saying. Look at that. My man over here, remember, for 3 months. You are doing amazing things. Keep rocking. I really appreciate you, and thank you for the 20 spot. Appreciate that. But yeah, he was they were in a stolen car that matched the description of the shooter. One of them had the stolen weapon that was stolen from his father weeks before the crime. And what JoJo said is crazy. Like, when they know you're innocent, when they know you're innocent and they still do some fuck shit. Excuse my language, man, but you know what? I gotta keep it real, right? Some bullshit. Stole the gun from the dad. He had a fresh wound above his eye. It was split open, right? Which happened hours before the red rum charge. Fucking hours before the murder, I'll say it. That's why YouTube ain't sharing my shit, And the police had 25 pages of notes about these men in the prosecutor's own file. But guess what? The jury never saw it. Are we surprised? The jury never even saw that shit. See, while everyone's concentrating on the Tupac trial, which everybody and their mother's streaming it, do you know why? For views. That's the only reason why they talking about Tupac. For views. You know what I mean? Like, everyone knows the Keefe D situation, so everybody's got the Tupac trial on for one thing only, for views. To get that energy. Which is fucking disgusting. You know what I mean? Which is disgusting. Write that down. But I mean, the eyewitnesses, man, especially the one with the mental illness, man, that's not the gold standard, right? And the jury never got the tools to even understand that. You know, and I'm glad that Stephen's lawyer reminded them that the DNA, the bullshit science, right, excluded Stephen from the weapon and excluded him from the victim's clothing. And excluded him from the victim's clothing. You know, and I like what Tessia said. Justice was not done. Because she's right. It wasn't one mistake. You know, it was a whole bunch of mistakes. It wasn't one witness. You know, it was a snowball effect. You know, and this is what happens, right? When a system is more committed, right, to defending its past than correcting its future. And that's what it wanted to do here. And that's what it's going to try to do in the Eddie O'Brien case. They're going to get up there and saying wrong, 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 wrong. And hopefully the judges, like in this case, they see the evidence in Eddie's case. Because we know it's not just Stephen Pina. We know it's not just Eddie Wright. We know it's not just these guys. You know, we know it's a lot more than that, right? But man, this machine, man, these courtrooms, you know, the Commonwealth get up there and they try to defend the indefensible, and the judge allows it. And I'm glad the judges in this case finally said enough is enough. That Lindsay Clancy case, I don't know, man. That case is just like, you know, you see these stupid videos on TikTok where these stupid, excuse my language, right? Because this is the right saying, these stupid broads, right? Excluding all you ladies in my chat, right? These stupid people hanging themselves out a window. One girl almost fell out her second floor window. Right? One girl had dish soap all over her to show how, oh, if she was bleeding, it would have dripped like this. It would have dripped like that. You know what I mean? About when the lady jumped out the window. I don't know, man. But yeah, that case is bogging a lot of shit down. And I understand, man. It's sad. It's sad. It's sad. It's sad. But you know what? Insanity, it's not a magic eraser. You know, like there's 3 children that were killed. You know what I mean? Someone needs to be held accountable for that. Nobody's saying anything about the children. And a lot of people say, well, the Lindsay lady didn't know what she was doing. Well, she had enough mind to try to end her life after she did that. So she must have consciousness of guilt. She knew enough to try to throw her ass out the window. You know, and I don't think once her attorney has said that they didn't do it. They keep saying they did it. You know? They keep saying it. So, you know, it sucks for Clancy. It really, really does. But, you know, the lady killed her kids, man. You know, she killed her kids, so she's going to have to be accountable, whether it's in, which I don't see her going to prison either way. You know why? Because the prison ain't going to want to pay to take care of someone that's paralyzed. It's going to be too much money. They'll send her to Bridgewater, where it comes out a different type of budget. You know, and she'll go to the Puzzle Factory. But that is crazy, man. So right after all this, right? And I like how Tessia laid out what the jury never heard. that these two other guys, Brian and Anthony, they were arrested a couple weeks after the murder, right? A stolen car that matches. They didn't even get rid of the car. These guys were friggin' idiots. But they walked for 30 years. They got away with a crime that didn't happen. Anthony Woods. Wasn't there another Woods that was killed in Cambridge under Riley's watch? Woods. I gotta check on that. But yeah, that was definitely something, people, you know. I mean, some cases fall apart because of one mistake, but I think this case fell apart because the whole damn thing was broken. You know what I mean? But it's too bad it took 30 years because you kept a man in prison using a case that was held together with friggin' duct tape, right? And wishful thinking. Cook that. And two witnesses who couldn't keep their eyes open. They couldn't keep their story straight if you stapled them together. And the other thing, the weapon. It was in someone else's hands. It wasn't Stephen's. And how do you dismiss the fact that one of them had a fresh wound on their head, you know, that matched a robbery victim's description from earlier that same day? That's not a coincidence. That's a trail that the police walked right past, you know, and then having the 25 pages of notes in Stephen Pina's file, that's crazy. That's crazy too. That is crazy also, man. All right, give me a minute. We'll wrap this up. I'll be right back.
Yeah, we gon' take a moment before we dive in. Let me show some love, you know. Yeah. Turn on the stream, feel the energy rise. Shout out to the fam, the ones in the skies. Every comment, every laugh keeps the vibe alive. You're the heartbeat of the chat, yeah, we thrive. Pulling up each night, ready to roll. You make this place lit, body and soul. Minds in the back, heavy lifting, they don't play. Keeping it smooth, watching traffic every day. Peacekeepers on alert, holding down the fort. Crew full of love, every stream they support. To the chat, to the crew, yeah, we shine bright. Are the backbone of the night, holding us tight. To the members, true believers, making it real. You're the pulse in our heart, let's do the deal. To the chat, to the crew, yeah, we shine bright. Are the backbone of the night, holding us tight. To the members, true believers, making it real. You're the pulse in our heart, let's do the deal.
We see you dedicated, going the extra mile. Not just watching you invested, that's the style.
Lights on, vibe strong, every show's a hit. Commune together, can't take a minute to quit. You keep us going, no watered down vibe. From the chest to the miles, know we thrive. Major respect to the ones who keep it clean. Clean up crew rolling, y'all know what I mean. Don't try it today, they say with a glance. Bringing peace to the chaos, giving us a chance. To the chat, to the crew, yeah, we shine bright. Y'all the backbone of the night, holding us tight. To the members, true believers, making it real. You're the pulse in our heart, let's do the deal. To the chat, to the crew, yeah, we shine bright. You're the backbone of the night, holding us tight. Just know this is true. We appreciate every single one of you. This is our moment, community's the key. Let's get it poppin', let's set the stream free. So here's to the chat mods and members like, oh, you're the heart of the stream and that's never getting old. Now let's get into it, yeah, we ride on time. With you by our side, every night's a prime. Yeah, we out take a moment.
Hey, Jojo, don't go nowhere.
Let me show some love, you know? Yeah. Love. Turn on the stream, feel the energy rise. Shout out to the fam, the ones in the skies. Every comment, every laugh keeps the vibe alive. Hear the heartbeat of the chat, yeah, we...
Innocence shattered in a world so torn. They said it was fear reopening the doors, filled with whispers behind closed floors. A white boy convicted made it look fair, but in the shadow of justice the truth laid bare. Eddie was a name, but just a pawn in the game. Sacrificed and railroaded, nothing felt the same. Oh, just a boy from Somerville. They played with his life as if it was a thrill. Politics and pressure, shadows at play. Innocent hearts lost in this twisted ballet. He folded like glass, the DA showboating, just trying to amass. The system wanted justice, but justice was blind, changing the laws, leaving truth far behind. Remove the judge who dared to be just. Eddie was demonized in the world's cruel thrust. Size mattered not when politics run deep. From day one he fought, but all they did was sweep.
All right. Already. Your boy said, I disagree with you. Now, what I will say about the case, I think I talked about it a couple of days ago, right? I had some notes on it too. I just don't know what the hell I did with the friggin' notes. But what I will say is that I think this case with the Clancy lady is definitely heavy, man. You know what I mean? It's tragic, horrible. You know, it don't have a clean ending or a comfortable explanation, no matter how you spin it. You know what I mean? I kept saying it the Nancy Clancy case, you know, but Lindsay, and before we go anywhere, before we talk about, you know, we're not going to get much into it, right? But there's a lot of mental health that goes with this, you know, a lot of reaction. You know, insanity is not a magic eraser. You know, there's 3 children, you know, that's in the center of this story. And that's the part that I can't soften. That's the part that I can't, you know, I don't know. I can't sugarcoat it anyway. I would be a horrible juror on this case because I can't get by the children. There's 3 children that are expired, and then you got someone that tried to throw themselves out a window, you know, and someone needs to be held accountable for that. You know, I mean, people hear insanity defenses, and they think it's a magic eraser. You know, like if you say the right psychiatric word, the crime disappears. But I don't think it's not that clean, right? Insanity don't mean I didn't do it. We know she did it. She has not denied doing it. You know, she's saying, yeah, I did it, and my mind was broken. I mean, the act still happened. I can't get by that. If you take a couple pills, if you take some oxys and you go get in your car, even though the oxys are prescribed, and you run a bunch of people over, well, the explanation don't bring the children back, does it? Yes, absolutely. The doctors failed Lindsay. They absolutely did fail her. Yes. But just because they failed her, she still ended the life of her children, bro. And she knew enough, right? She knew enough to know that she did wrong. You know what I mean? I agree. They failed her. Telehealth, all this stuff, the prescriptions. And they know, another doctor knows when another doctor gives you prescriptions. They absolutely, I'm not saying they didn't fail her, bro. But what I am saying is that she did this. She did this act. She committed that act, right? And then after that, she tried to throw her ass out the damn window. And I think the part that people struggle with is you can acknowledge mental illness. You can acknowledge the suffering, right? You can acknowledge that somebody snapped under the imaginable pressure. Come on, Jojo, you go take a handful of Vicodins or something, or a handful of perks. You know what I mean? And you go out and do something hard. Well, the doctor gave me these perks to go with these Vicodins, to go with these Lortabs, to go with these Rembrandts, to go with these Somas. You still did that. You still committed the ultimate sin. Hold on. Wifey's at the door. My bad, it was my daughter, wasn't even her. No mother in her right mind would do this to her child. And I get that the doctors failed her, absolutely. You know what I mean? And under some crazy, crazy pressure, and she snapped. But you still got to say somebody needs to be held accountable for this. Because accountability isn't cruelty, right? Accountability isn't clarity. 3 children are gone, right? 3 lives are ended before they even begin. You know, and I think their futures are totally gone. Their futures are erased, you know, and what happens? You know, the Lord doesn't get to shrug. The community don't get to shrug, you know, I don't know. Someone has to answer for it. I'm going to say, I don't know. My bad. Sorry. Sorry's overrated. You know, but even if it's complicated, right? Even if the answer is painful, you know, yes, the doctors, you know, did it wrong. They failed her. Absolutely. I agree with you 100%. But even if the answer is wrapped in mental illness, even if it is wrapped in trauma or whatever you want to call it, right? It don't disappear because the story hurts. You know, can compassion and responsibility coexist? I mean, they think if they could show compassion for Lindsay, right, for her mental state, that you're disrespecting the children, right? Or if you demand accountability, are you ignoring her suffering? That's the question, right? If we show compassion for Lindsay, right, are we disrespecting the children? And if we demand accountability for Lindsay, are we ignoring her suffering? I think right there, I think that's what it comes down to, you know, and can both be true at the same time? Maybe. I get it. I get it that she was struggling, you know. But you also got to say the 3 children are gone. And you know what? That demands accountability. That demands responsibility, you know? And you can hold space for mental illness. We can still talk about it. This case is a good test subject, you know, for people to say, all right, we got to change things, which I thought we already did. I can't get aspirin and another medication without 2 doctors knowing about it. I mean, I don't think it's contradiction. Right. There are no winners in this case. Absolutely, Your Honor. No winners. And I think that's the problem. You know, like I was just saying, that if we demand accountability, are we ignoring Lindsay's suffering? You know what I mean? Or if we're showing compassion for Lindsay, are we ignoring the children? She has to wake up every day. She gets to wake up every day. Yep, she has to wake up every day. And we don't know how she feels, really. You know, but that's why this case, I pretty much stayed away from it. But as I'm watching it, I'm just kind of like just thinking, looking at it and saying, you know, it's like, it's just hard for me to get by that she killed the kids. You know, and I haven't really watched a lot of the trial for these reasons. You know, I mean, I know enough to go over it and to see the bullet points, you know, and I've seen all the crazy videos, people hanging themselves out the window. That's the other thing, you know, she tried to throw herself out the window and have to think about it. Yeah, she has to wake up every day and she has to think about it. So is that punishment enough? Is that what you're saying? You know, I mean, no matter what you do, I don't know if you can ever truly punish her enough. But I don't think she'll go to prison. I think she'll end up in you know, in a hospital. Hey, I'm gonna kill him. No, I was yelling at the, you know, but yeah, she definitely does have to wake up. No, you don't have to put him away. No. I don't put him away. You have to wake up every day, you know, and you have to think about it, you know, and I get that the poor lady was struggling. It's just a shame, man. There's no winners. I mean, it looked like her husband, whatever he is, you know, he had one foot on his way out the door before this even came around to happening. You know, but yeah, no, it's definitely sad, man. It really is. You know, but insanity defense or not, it happened. And the children didn't survive. And somebody must be held liable. Not because we want revenge, right? Not because we want punishment. The laws exist, right, to protect the innocent. And if we let her walk, what does that say? You know, like, should there be any accountability at all? Even though the doctors gave you a whole bunch of meds to take, you still did it. What's stopping the next person to say, you know, the doctors gave me a whole bunch of meds? You know, and when children, you know, pass away at the hands of a parent, man, that I don't know if we can look away. I don't know. You cannot hide behind sympathy, right? Can't pretend that it evaporated, that it never happened. Mental illness explains the why, right? But it don't erase the what. But at the end of the day, I don't think this case is about sides, man. I don't think it's about politics. It's not about online debates. It's not about who we feel is right. It's not about what we feel, because after this Clancy case is over, there's going to be another case on Law and Crime TV, and we're going to forget about Lindsay, and we're going to be on to the next thing. 48 hours news cycles, man. You're only 48 hours. If you can survive the 48 hours, they'll be talking about something else next, unless you're Turtle Boy. You know what I mean? But it's really about them 3 children who should still be alive right now. And when you center them, right, truly center them, focus on them, focus on the children, don't focus on Lindsay, does the path become a little clearer? Now, we can acknowledge Lindsay Clancy's, suffering. We can acknowledge her mental collapse and that she has to wake up every day. Everybody's talking about Tupac. We already know basically the Tupac thing. Everybody wants to talk about that because Tupac right now, with everyone talking about it on YouTube, it's about clicks. It's about people clicking. If they want to make that money, But back to this, we really can't pretend the crime didn't. And I will talk about that in a minute. We can't pretend the crime didn't happen, right? We can't pretend the children aren't gone. We can't pretend accountability is optional. 3 children are dead. Dead. Them EMTs got to live with finding them, and the truth demands a response, and I get it. Compassion matters. Mental health matters. Absolutely. But accountability matters too. Accountability matters too. Give me a minute. I got to run to a little boys' room, and I'll come back, and we'll talk a little bit about Tupac. Not for the money.
Let me tell you about a kid, only 15 years. Eddie O'Brien, caught in the gears. Political pawns, they played their game. Power and money all in his name. But was tight with wealth, no simple fate. Climbed the ladder, sealed Eddie's state. Wayne Butter, prosecutor with a purpose. In the court of politics, none could touch us. This ain't just a story, it's a legacy. Eddie was the stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Riley and Bud, best friends since youth, built a law firm, they spun the truth. When Riley took the case, he was never alone. Built on foundations, powerfully grown. With the Budwell Network, they made a show. Charlie Baker in the mix, he's part of the flow. All linked together, climbing the heights. On Eddie's back, they rose to new sights. This ain't just a story, it's a legacy. Eddie was the stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Kimberly Budd, her name now in lights. Chief Justice of the court in the highest of fights. Calls Riley godfather, mentor, uncle too. Let that sink in deep. Eddie's pain paved through. Judge Heffernan ruled fair, you played your part. But the pressure came down like a storm in the dark. It wasn't about truth, wasn't about rights. It was all about power and their political heights. This ain't just a story, it's a legacy. Eddie was the stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Eddie got used by a system so cruel. A pawn on the chessboard, they played him as a fool. So remember his name, let it echo, let it be free. Eddie till it's backwards. Fight for the right you see. Can we keep it real, Thomas? Let the truth ignite. We don't beg
me tell you about a kid, only 15 years. Eddie O'Brien, caught in the gears. Political pawns, they played their game. Power and money all in his name. But was tight with wealth, no simple fate. Climbed the ladder, sealed Eddie's state. Wayne Butter, prosecutor with a purpose. In the court of politics, none could touch us. This ain't just a story, it's a legacy. Eddie was the stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Riley and Bud, best friends since youth. Built a law firm, they spun the truth. When Riley took the case, he was never alone. Built on foundations, powerfully grown. With the Budwell network, they made a show. Charlie Baker in the mix, he's part of the flow. All linked together, climbing the heights. On Eddie's back, they rose to new sights. This ain't just a story, it's a legacy. Eddie was a stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Kimberly Budd, her name now in lights. Chief Justice of the court in the highest of fights. Calls Riley godfather, mentor, uncle too. Let that sink in deep. Eddie's pain paved through. Judge Heffernan ruled fair, you played your part. But the pressure came down like a storm in the dark. It wasn't about truth, wasn't about rights. It was all about power and their political heights. This ain't just a story, it's a legacy. Eddie was the stone that shaped their destiny. With every connection, every hand they shake, Eddie's case became the ground they break. Eddie got used by a system so...
Yes, free Eddie O'Brien, of course, you know, first and foremost, you know, free Eddie. You know, my daughter stopped over on her lunch break real quick, you know, but I think the biggest problem for the Keefe D case, you know, my glasses, I can't see shit. You know, with the Keefe D cases, for 15 years, you know, Keefe D went on camera, went on Vlad TV, went on podcasts, went on BET, you know, wrote a book, gave interviews, gave a proffer, you know, gave statements, you know, and told the same story over and over and over. We know it by heart. I was in a white Cadillac. I handed the gun to the shooter. You know, he directed the retaliation. He knew the motive. You know, he described everything. You know, he described the route. He described the moment the shots were fired. You know, and then what did he do? He said, oh, it's gang business. He said it's revenge for the MGM fight, for the jump-in. But the state don't need a shooter. They don't need a gun. I thought. No, maybe not. They don't need a witness, right? They have Keefe D narrating the crime itself. So what's the prosecutors going to say? They're going to say, this is not a mystery. Keefe D told you exactly what happened to Tupac, right? And then when you go back to 2008 and 2009, because I looked this up the other day, and when you look at the proffer agreement, you know, Keefe D sits down with the feds, you know, during a drug case that they had him on. They said, tell us about your involvement in the Tupac murder. You know, you have a proffer, which is basically you have immunity for today. We'll give you immunity today. Anything you tell us today, don't worry, we'll file it away, you know. And he admitted involvement in the Tupac case, you know, and he talked, he gave details, he sat down with the feds. The state's going to argue that he wasn't tricked, he wasn't confused, he knew exactly what he was doing. He voluntarily told the story, and then when times got tough and he needed the money, he went out and sold his story. He sold it to Vlad TV, you know, he sold it to BET. He wrote a book, even though he said he didn't write the book. He read it from the book. He read it from the book. I mean, but one thing about the prophet statement, they can't always be used directly. They can't always be used to impeach somebody if he changes his story, and he has changed his story. I bet now he's changing it. I bet now he's changing his story. And even though them prophet statements, right? Even though them prophet statements were signed and everything, but this is going to give prosecutors a clean pat. He confessed before he was famous for confessing. That's what Keefe D got famous for. He got famous for confessing, and, they're going to get him here. Is he going to flip it on appeal? Maybe he'll be dead and gone by then. You know what I mean? But they're going to convict him. You mark my words. That's Tupac. No matter who's sitting up there, they're going to convict him. And Keefe D is the last living conspirator. Everyone else in the car is dead. Orlando Anderson, he got shot. DeAndre Smith, gunned down. Terrence Brown, goodbye. Keefe D's the only one left. And the prosecution will say the last surviving person is the one who spent years bragging about it. So what are they going to frame Keefe D as? They're going to frame him as the boss, the uncle, the gang shot caller. Uncle is something. Uncle's respecting the gangs. The elder, he directed the younger members, and this does fit what Nevada is saying. And it does fit their aiding and abetting statute perfectly. They're going to say the MGM fight provides the motive. There's your motive. The MGM. The state's going to use the MGM surveillance footage as an emotional, as something to anchor it. They're going to argue that Tupac and Death Row assaulted Orlando. Keefe was Orlando's uncle, right? So the Crips retaliated. That the guys in the Cadillac hunted Suge and Tupac down. Right? That it was gang retaliation. It wasn't random. That's what they're going to say. That's what they're going to say. This is going to give the jury, this is going to give them something simple. You know what I mean? Some simple motive that people can understand. They don't really have to think about and get confused. They beat up his nephew. He ordered the hit. They got the Cadillac, the route that the Cadillac went. They got the timeline. It all matches Keefe D's story. If you look at his interviews, go to Vlad TV if you want. If you don't know, wait, Vlad TV, VLAD, DJ Vlad. He did probably the most detailed interviews. Vlad has everything. The witness accounts, the police reports, the way the Cadillac drove, not the way it drove, like if it was running right, the direction the Cadillac went. And one other thing, how does Keefe D know the exact rule unless he was there? You know what I mean? Even if he tries to recant, the state is going to argue. The state's going to argue even if he tries to recant on what he's saying. You know, he told the truth before he had a reason to even lie. You know? And talk about Keefe D's book real quick, right? I mean, it's probably a prosecutor's dream. Go get the book. I think it's called Compton Street Legend. You know, and it's a confession wrapped in his storytelling. I mean, he names the shooter. He describes who he handed the gun to. He explains the motive. He places himself in the car, the friggin' idiot. You know what I mean? He details the plan. He published his guilt. You know what I mean? And now the jury can take published admissions seriously, right? So now people are like, yeah, but he recanted. But that's going to be treated like a damn lie. Now Keefe D is going to say he wasn't even there, right? Give me a minute.
In a world made of shadows, where the truth feels far away, you find yourself behind bars for a price you didn't pay. Fight your case with every breath you take, standing on your truth in the face of all this heartbreak. I didn't do this, you shout, but they turn their heads away, ignoring echoes of your innocence. You face another day. And what does the parole board say? Drowning in the protocol. You show no remorse. You're not fitting the role at all. How you gonna take responsibility for a storm you didn't cause? Like blaming someone for the rain just because they were out. The system don't care about your truth, they care about compliance.
All right, bro. I guess I'm out of here. Appreciate y'all.